Order item 16, number 1901 of 2014.
Impute order of the appellate authority as well as the order in the review application are hereby set aside in quest. However, the matter is remanded to the appellate authority for fresh consideration in accordance with the law on the basis of the records after affording due opportunity of hearing to both the parties.
I'm grateful, madam. Obliged.
Item 17, WBC 5030 of 2024.
The respondents are directed to reconsider the case of the petitioner for grant of subsidy financial assistance to the petitioner under the scheme. In the event the petitioner is found to have complied substantially and any deviation is curable, claim of the petitioner for subsidy may be granted. Consequently, impute order letter dated 09/07/21 by a Deputy Director of Tea Development is set aside in quest. Just reconsider if the defects are curable.
Any mention?
Complete, my lord.
Yes.
My lord, I'd like to mention item number 2 of the list. The counsel for a petitioner is not well, my lord, and says, madam, may kindly be adjourned for today. Can it be listed next Thursday? Short day.
You are for petitioner.
Petition ends, I think.
It's a simple matter.
My lord, she is not well, my lord, today. And won't be able to come.
On the ground of Miss M.S. Ensakya, learned counsel for petitioner, is not keeping well. Come on, Mr. So-and-so,
MP Chaudhary.
learned counsel, appearing on her behalf, pressed for adjournment of the matter for 3 weeks.
Well, next Thursday, short day, if it's possible.
Thursday, not possible, may not be possible. We'll see. After a week, huh?
After.
Praise the Lord. List the matter after a week.
Okay.
Please, your lordship.
Yes.
With the consent of the other side, I'd beg to mention item number 9. Lordship had circulated an adjournment slip yesterday as a matter is pending.
On the prayer of MS?
Miss B. Poddar.
B. Poddar. For respondent?
Respondent number 6, your lordship.
I'm for the petition.
Respondent.
I'm for the petition.
And the prayer not being objected by Mr.
Are they?
Are they? Little counsel, but list this matter after
4
2 weeks.
4 weeks.
4 weeks, your lordship.
2014 matter.
Only thing is, the case, Lord, here I have challenged certain thing, Lord, which is already subject before the Madras High Court. And in fact, Lord, basically, Lord, in this case, we wanted the Assam Cricket Association to come out within the purview of the Right to Information Act. Lord, the CIC has already held that the
Cricket Association.
yes. The CIC has already held that the BCCI is already it comes under the purview of RTI. And that has been challenged in the Madras High Court, which is pending.
Okay. Then 4 weeks.
Lordship.
Much obliged.
May it please your lordship.
Yes.
Lordship, with the consent of the other side, I beg to mention item number 10, lordship. He has some personal difficulties, lordship.
2015 matter.
Lordship, after 2 weeks, lordship, some personal difficulties.
You're for petitioner.
Respondent, Lordship.
Who is the petitioner?
We have taken consent.
On the, no, on the prayer of Mr.
D. Roy, Lordship,
Roy.
on behalf of T.S. Hazarika.
Mr. On behalf, appearing on behalf of Mr. T.H. Hazarika, London Council for the respond number 6.
8.
8. And the prayer not being objected to by London Council for the petitioner. Let this matter be listed after 2 weeks.
After vacation.
After 3 weeks.
To
Obliged, Lordship. Make this, Lordship. Lordship, I'm praying for some accommodation, my lord, in item 11. Dr. Sharaf will be out of station, Lordship. If,
was
I also intimidate the same to the learned respondents.
It was fixed on consent only.
It was fixed when.
We have, in fact, we have heard the matter.
Yes, and I don't know, he has informed me now.
Subsidy, it is a subsidy.
Yes, he has
So,
informed me
Better,
now.
better after 3 weeks.
That was annually, Lordship.
As per the
Mr. So-and-so, Learned Counsel, appearing on behalf of Mr. Dr. Asik Sarab, Learned Senior Counsel for the petitioner. Submits that Dr. Sarab, Learned Senior Counsel, has some personal difficulty. Therefore, prays for listing of the matter after 3 weeks. Where Mr. R.K. Chaudhary, Learned DSGI, raises no objection. Mr. In view of, accordingly, let this matter be listed after 3 weeks.
Obliged, Lordship.
Lordship, back to mention 2 items
Yes.
for admissions. Listing of 2 items for admission.
What is the urgency?
Urgency is, Lordship, it is a settlement matter. Settlement matter.
After a week.
Please, Lordship.
Hmm.
Lordship, I beg to mention listing of an item for bench 4 and 5.
Hmm.
So, Lordship, we want the matter to be listed so that it can
Who
be.
is
referred to
dealing with
meeting.
the bench 4? Hmm. Who is having that? You make a mention before this thing.
No, Lordship, this matter pertains to bench 4 and 5, Lordship. I approached the bench 4 and bench 5. Apparently, they sent me back here, Lordship. Lordship, any date maybe.
After a week.
Obliged. Much obliged, Lordship.
Yeah, because I would like to mention item number 12.
Hmm.
For a private respondent, Lordship.
Yes.
Taking consent from the data cell.
Hmm.
Therefore, possible for the well,
Why?
some difficulty.
Yes.
Deeply
After 2 weeks.
deeply obliged.
They make it 3 weeks.
Your peace, Your Lordship, I beg to mention item 15.
Hmm.
Yes, after 2 weeks, the conducting council is having some difficulties today.
Okay.
Obliged, Lordship.
Hmm. Make it 3 weeks.
May it please, Your Lordship.
Yes.
My lord, the matter relates to award of a contract at my lord Sairang in Aizawl, my lord.
Hmm.
Now, there are certain disputes, there is an interim order which is protecting us. But my lord, by the actions of the authority, virtually, my lord, the contract has been rendered infructuous. So basically, we have filed this IA, which is item number 5, my lord.
Hmm.
There we are praying for, my lord, refund of our honestment, to which railways have not filed their affidavit. If they are otherwise accepting the position, then we'll proceed.
Which one? IA?
2987, my lord.
29. Yes.
2987, my lord.
Hmm.
It was filed on 3/9/25.
Yes, 2987.
It would be as
Boro.
My lord, before my lord, my senior colleague starts, my lord. Actually, my lord, the number one item is, my lord, IA number
For vacating.
2916.
Yes, yes, I've seen.
Yes, my lord, that is, my lord.
Yeah, we'll see. We'll
Ma-
wait for
ma-
some time.
ma-
Yes. Now, 2917, my lord, 87, here we have filed for praying for, my lord, direction to the opposite party for release of the security money amounting to 38,18,900.
Work is completed.
No, my lord. Well, it's a peculiar case, my lord. Actually, they're insisting upon the contract conditions to terminate the contract.
Yes.
But the fact of the matter is, my lord, they have waived all their right. Because straightway when the LOA was issued, my lord, without completing any formalities, were allowed to proceed with the work. Because there was some urgency in the matter, my lord.
Is the issue is not arbitrable?
No, my lord. Now, that is an issue which will come later on, my lord. First of all, lordship will kindly see the conduct of the railways. How they have, my lord, flouted the orders of the, my lord, there is an order of status quo ante also which they have not followed. Now, if your lordship kindly gives me some time, my lord, I can just address your lordships on the merits of the case. Just to have an idea, because it's a facts are very lengthy, my lord. Now, if your lordship would kindly take the writ petition, my lord.
You are challenging the termination.
Yes, I'm challenging the termination. My lord, we have no problem going to arbitration, but we must be paid for the work we have done, admittedly which you have done. If they pay for the work which you have done, if they.
By this IA, you are seeking your the security,
Yes.
which security amount?
Look, since, my lord, they have already, my lord, surrendered, my lord, since, my lord, the security amount was, my lord, they are seeking the return of the security amount, my lord. My lord, we have terminated the contract, my lord. And, my lord, this termination is not, I'll show from the record, my lord, that it is not arbitrary and it is as per the, my lord, clauses of the contract, my lord. We have terminated the contract, my lord. My lord, when, my lord,
So they are not entitled for which security amount?
my lord, there is an arbitration clause also, my lord. And
No,
my lord,
that
if-
we have seen.
If they, my lord, wants, my lord, that, my lord, their demands should be made, my lord, they can, my lord, file representation, my lord. My lord, we will consider it, my lord, but only thing is, my lord, the rail line is completed, my lord. The
No.
Commissioner of Railway Safety has, my lord, given certificate, my lord. It is going to be open, my lord, in this month, my lord. And, my lord, the originating station, my lord, from Mizoram, my lord, we could not proceed, my lord, to the work, my lord. Where, my lord, the inauguration will take place, my lord. For this, my lord, interim order, my lord. And, my lord, they are seeking, my lord, the return of the, my lord, their earnest money, the security deposit, my lord. So they have no intention to complete the work, my lord. And, my lord, I'll show.
No, you have already terminated.
Yes, my lord. But, my lord.
Are they entitled for their security deposit amount?
My lord, as per the clauses, my lord, if it is terminated, my lord, they are supposed to lose this, my lord, this amount, my lord.
There is no clause.
My lord, but, my lord, the arbitration agreement is there, my lord. They can go very
It's
well.
okay, we'll go to that is on the merit.
Let me place 2-3 documents, then lordship will get an idea of the whole thing. Now, first, my lord, they are saying that for not complying, not conforming to certain requirements, our contract was terminated. First, if your lordship would kindly come to, my lord, page number 136, my lord, of the writ petition. LOA 136 to
Home C.
137, my lord, the LOA.
No, this is IA. Writ petition. Affidavit has been filed or what?
Readings are complete.
These are complete, my lord.
So better to Instead of
Yes,
vacating, we'll dispose of the matter.
yes, yes,
Hmm.
yes, we are prepared, my lord.
Yes,
My lord will kindly come to page 138, my lord.
138.
7th line from the top. As the lordship got it, my lord. The performance security shall be valid. The performance security shall be valid until 60 days of the expiry of the defect liability period specified in clause 15.1.1 of the EPC agreement. Until such time, the performance security is furnished by the contractor pursuant thereto, and the same comes into effect. The bid security shall remain in force and effect, and upon such furnishing of the performance security, the authority shall release the bid security of the contractor. So we have, my lord, already furnished the performance security. For avoidance of doubt, the parties expressly agree that contractors shall provide no later than 30 days prior to expiry of the performance security for the defect liability period specified in clause 15.1.1 of the EPC agreement, a performance security in respect of the extended defect period as specified in clause 15.1.2 of the EPC agreement for an amount equal to 5% of the estimated cost of the structure.
Yes.
Now kindly come to the page 139, my lord. First subpara. The entire work shall be completed within 730 days from the appointed date. Page 139, my lord.
Yes, yes.
Entire work shall be completed within 730 days as per Article 26.1 of the EPC document. You are hereby authorized to commence work on the strength of the letter to ensure completion of the work as per conditions of the tender document. EPC in this regard, you may contact so. Therefore, my lord, virtually by this paragraph, I have been asked to proceed with the work without complying with the other requirements. So here is a case, there is a waiver on their part. Because of the urgency involved in the case, they called upon us to proceed with the work immediately. Now, in normal circumstances, my lord, if this clause would not have been there, then they would be justified in what they are saying. Now, my lord, we will kindly come to page number 371. That's part of the additional affidavit of the petitioner.
Yes.
Now, this is a letter by railway to the petitioner on 28/1/25. In reference to the above submission of joint venture agreement as mentioned in clause 3, clause section 3, subpara so and so of RFP document, the joint venture agreement between members of the joint venture to whom work has been awarded with the same shareholding pattern as was declared in the joint bidding agreement document submitted along with the RFP shall be got registered before the sub-registrar, registrar, sub-registrar under the Indian Companies Act, or before the sub-registrar, registrar under the Indian Partnership Act or LLP Act, and deposit the original copy of the joint venture agreement within 45 days of receipt of the LOA to the authority. A separate PAN shall be submitted for JV. The document pertaining to entity including PAN, bank account detail, etc. shall be furnished to the railways before signing the contract agreement for the work. Now, this is important. Hence, you are requested to submit joint venture registration as mentioned in the above clause for execution of the CA for further necessary action, please. Then, my lord, will kindly come to page 372, 373. Similar requests were made. I will not trouble your lordships with those. Now, please come to page 377. what is most important is, my lord, the date of this letter. This is 26/2/25. It will have a bearing. I'll come little later. Now, this is the, my lord, draft notice which was given to us as to why they would like to terminate the contract prior to signing of the EPC. LOA against the tender issued on so-and-so, white dated so-and-so, dated so-and-so. As per S number 18 of clause 1.1.2 of KIT RFP document, performance security is required to be submitted within 30 days of issue of the letter of award, that is within 6.12.24. Performance security was submitted by you by your letter under reference. As per serial number 19 of clause 1.1.2 of the RFP document, contract agreement is to be signed within 15 days of submission of the performance security, that is within 21/12/24. Additionally, as per clause 3.3.8 of the RFP document, the original copy of the joint venture agreement registered before so-and-so under the Indian Companies Act should be deposited to the authority before execution of the agreement, that is within 21/12/24. By this office letter dated 28/1/25, 14/2/25, and 20/2/25, these are the letters which appear at page 371, 372, and 373. You were again requested for submission of the registered joint venture copy. However, my lordship will kindly mark this word, my lord. Why this office letter dated, you were again requested for submission of registered, it was never done, my lord. However, this registered joint venture copy has not been submitted to authority till date, due to which signing of the contract agreement is being delayed. As you have failed to submit the requisite document, that is registered JV agreement, to the authority for signing contract agreement, even after repeated request by the authority, thereby delaying in the signing of the contract agreement within due date, you are hereby given 15 days notice in accordance with Article 21 of the draft EPC agreement to submit the desired document. Failing which, authority may terminate this agreement and take further action as per RFP. Now, if your lordship kindly comes to 150 for a moment, my lord. We have already submitted this, my lord. Page 150. Kindly mark this date, my lord. Page 150 of the writ petition, my lord. Now, right hand side, there is an endorsement received on 7/3/25. Then lordship will see date 5/3/25. With due respect, we beg to state that we are submitting here with the following documents: original JB, etc., number 7, my lord, acknowledgement copy of the registration of farms. So we have already submitted. Lord, as original joint venture agreement was furnished on 5/3/25, that is within 15 days from 26/2/25, the termination notice lost its efficacy, my lord. They gave us 15 days time. And within 15 days we gave it. Now this termination notice was taken to its logical end by my lord terminating the contract.
So this, our contract is signed on 7/4.
Then, my lord, if your lordship should kindly page 151. My lord, engineering, procurement, and construction agreement, which we call EPC agreement. My lord, kindly see the date down below. Signature valid, digitally signed by Suresh Kumar Jain, 7/4/2025. No, my lord, they wanted us that we should furnish the original joint venture, the registered agreement within 15 days from 26 to 25, which we gave. Then my lord will kindly come to now let us see the relevant clause, my lord, which your lordships will get at page number 82. Three point 3.8 of the IPT, my lord.
82.
In case selected bidder is a joint venture, I'm sorry, my lord, page
Yes.
82 on top clause 3.3.8.
Yes.
In case selected bidder is a joint venture, then on issue of LOA, the joint venture agreement between members of the joint venture to whom work has been awarded with the same heralding pattern as was declared in the joint bidding meeting agreement document submitted along with the RFP. There are two requirements. One, shall be got registered before sub-register, register Indian Companies Act, etc., etc., etc. Then, my lord, and deposit the original copy of the joint venture agreement to the authority before execution of the agreement. Now, my lord, 5.3.25 is the original registered joint venture agreement, and 7.4.25 the agreement was executed. So, what is my fault? Because the termination notice was on the count that if you do not comply this requirement within 15 days, from 26 to 25, then you incur the disqualification. That you have complied with. Now, my lord, termination order to the first. Now, if your lordships will kindly come to page 308, my lord, the termination order. My lord, these are all extraneous reasons, my lord. These are not at all germane. Please come to page 309, my lord. My lord will kindly come to the first subpara. As per clause 19 of clause 1.1.2, contract agreement is to be signed within 15 days of submission of performance security, that is 21/12/24. Additionally, as per clause 3.3.8 of the RFP document, the original copy of the joint venture agreement registered before register, sub-register, so and so, should be deposited to the authority before execution of the agreement, that is within 21/12/24. Due to non-submission of this registered joint venture copy to the authority, the contract agreement could not be executed within due date, that is 21/12/24. This delay in execution of the contract agreement has direct impact, caused delay on appointed date and completion date of the project, which caused a material adverse effect on the project and on the authority. Therefore, default occurred as per Article 21 of the EPC. As per Article 21.1.1, you had to cure this default within a cure period of 60 days by 19 to 25. However, you did not notice the requisite documents to the authority for signing of contract agreement and therefore failed in curing the default within the cure period of 60 days available as per Article 21 of the contract agreement. Now, my lord, just to appreciate whether they are stating the right things, please come to 371 for a moment, my lord. That notice which I have shown. 371.
Yes.
In fact, this is the kindly see, my lord. In reference to the above submission of joint venture agreement, as I've already shown it, my lord, as mentioned in clause section 3 of subpara, joint venture agreement between the members of the joint venture to whom work has been awarded with the same shareholding pattern as was declared in this so should be so and deposit the original within 45 days of the receipt of LOA to the authority. As hence you are requested to submit as mentioned above in the above clause for execution of CA for which we did. I was reminded by page 372 and 373, and by page 151, my lord, we have complied with this.
Page 377.
Please come to my lord, page 377.
Just wait.
No, this has been given effect in the final order. No, but then, no, see the show code, the show code,
Yes.
Now, my lord will kindly come to 377. I have placed this, my lord. Now, I have said, my lord, the date is very relevant. Date is 26 to 25. So, my lord, Article 21, which they have invoked in this case, finds place in the EPC agreement dated 7/4/25. How can an EPC agreement which was not even signed on that day could be invoked, my lord? On 26 to 25, clause 21 of the EPC agreement, which was signed on, executed on 7/4/25, it could not have been invoked. But even then, my lord, whatever was expected of us, we have done it.
Where is
Because-
that? Where is that EPC agreement?
151, my lord.
Wait.
I have just shown. My lord, 150 is the forwarding letter and 151 is the agreement. It starts at page number 151 and it continues up to 303, my lord.
Yes.
Yes. Now, my lord will kindly come to page number. Registration action na dekhao. Acha. Yes. Now, my lord, lordship will kindly permit me to place 309, my lord, the impugn order, which we are reading actually. Page 309, my lord.
Yes.
I am reading the first subpara. As per serial number 19 of clause 1.1.2, contract agreement is to be signed within 15 days of submission of performance security. That is within section 21/12/24. Now, kindly see, additionally, as per clause 3.3.8, the original copy of the joint venture agreement registered before registrar sub-registrar under the Indian Companies Act should be deposited to the authority before execution of the agreement within so and so. Now, my lord, my humble submission is, now this requirement that this should be signed before registrar or sub-registrar under the Indian Companies Act is absolutely wrong, my lord. If your lordship should kindly have the Registration Act for a moment. Registration Act. No. If your lordship should kindly have a look at my lord, I'm sorry, my book is not like this. Section 28, 29 and section 15, my lord. Section 28. Straightway, lordship may kindly come to section 29.
Yes.
Asani.
29, yes.
Yes. Place for registering other documents. Every document not being a document referred to in section 28 or a copy of the decree may be presented for registration either in the office of sub-registrar in whose sub-district the document was executed, or in the office of any other sub-registrar under the state government at which all persons executing and claiming under the document desire the same to be registered. My lord, section 29 in my humble submission is a residuary provision, my lord. Now, the exception is carved out in section 28, which already document which should be registered as per section 28. Save as in this part, otherwise provided. Every document mentioned in section 17, subsection 1, clause A, B, C, D, E, section 17, subsection 2, insofar as such document affects immovable property, and section 18, clause A, B, and C, C, shall be presented for registration in the office of the sub-registrar within whose sub-district the whole of the portion of the property to which the document relate is situated. In other words, my lord, in case of immovable property, is covered by 28. And our comes under, my lord, 18F. If your lordship would kindly come to 18, my lord. This is again a residuary provision, my lord. Section 17, my lord, prescribes the documents which are mandatorily required to be registered, and section 18 mandates, my lord, those documents in respect of which registration is optional. Please come to F. All other documents not required by section 17 to be registered. And joint venture agreement, my lord, it's a document which should be covered by 18F. Therefore, my lord, it has to be registered in the place where the document would be by the sub-registrar of the place. Now, my lord, this is a new requirement which they have brought in, my lord, at page number 309. 309, that's the issue and termination order. The third sentence of the first subpara. Additionally, as per clause 3.3.8 of the RFP, the original document of joint venture agreement registered before registrar service under Indian company. Where from you got it, Miller? Oh. And even 3.3.8 also does not envisage any such requirement. Well, you give us a notice, give us time to, Miller, rectify whatever we have not been able to do. We do it, then you switch on to the next point.
Page 403.
So, well, there is no requirement. And the registered joint venture agreement dated 7/4/25, which Lotif has already noticed at page number 151, was duly executed before the sub-registrar's office, which is the jurisdictional sub-registrar office covered by 18F read with section 29. And my lord, the railway, they cannot be permitted to go on improving their stand from time to time, my lord. So here is a simple case. You could not have invoked clause 21 because you issued the so-called notice on 26 to 25. On that day, EPC agreement was not even in force. So an agreement which was not executed, how am I bound by that? There was no privity of contract on 26 to 25. The privity of contract arose only on, my lord, 7/4/25.
We apply with 26.
And in any case, we have complied with the requirement which was envisaged in 26 to 25 later. We have done it.
They are bound by.
Now, can they turn around, my lord? And they're an authority under Article 12. And they're dealing with the rights of citizens. Merely because a railway project, because Prime Minister of the country is going to inaugurate it, that does not mean you will bulldoze all the rule of law. If I have to say that.
Yeah, it's optional. Because
Oh, no. No, 155 agreement.
one of the second which was forming project.
So now, Milord will kindly come to their affidavit. Now, what they say in para 9. Para 9 of the affidavit dated, Milord, 24/7/25, which will be page 491. Milord. Page 491.
Yes.
Now, my lord, 1, 2, 3, 4, 5, 6, 7. 8th line from top of the subparagraph. Sentence starting with additionally. Additionally, as per clause 3.3.8 of the RFP. I'm sorry, sir.
Just wait.
Okay.
As per clause 3.3.
Yes, my lord. Additionally, as per clause 3.3.8. Has a lordship got
Yes,
it?
yes.
Yes. Of the RFP document, the original copy of the joint venture agreement registered before the sub-register under the Indian Companies Act should be deposited to the authority before execution of the agreement within 45 days of issue of LOA. Well, 3.3.8 does not envisage any such requirement that it should be submitted within 45 days of signing of LOA. And further, my lord, requirement of Indian registration before register or joint register under the Indian Companies Act is also nowhere prescribed. Therefore, the period of 45 days of submission of original copy of the joint venture agreement is as per the provisions of the contract agreement. It is also clear that all the actions taken by respondent are as per relevant provisions of the contract agreement, and therefore the request of the petitioner to include respondents in person in petition by means of an appropriate application is not maintainable since all the actions has been taken for smooth functioning of the work. Now, my lord will kindly come to page number 1518, my lord.
Yes.
Now, my lord, please come to page 518.
Yes.
Now, in that page 150, lordship had noticed that was our forwarding letter, whereby, my lord, we have furnished our original JV, etc. And amongst others, my lord, our registration as regards sales tax. Partnership, sorry. Partnership, my lord. At page 150, serial number 7, that is envisaged. We have given those also, my lord. Kindly see at page 518, Department of Industries and Commerce, Haryana, list of the firm. So partnership registration firm certificate was also furnished. We downloaded from the website of the government of Haryana and we provide. Then my lord will kindly come to 506, where we have stated this aspect. Para 7.4.
Yes.
Because in the impugn order, they say that we have not given any proof of registration. So we are denying that. The submission contained under paragraph 10 of the concerned AOI, that is affidavit of completely devoid of.
This is your reply.
Yes, my lord.
Yes.
The submission contained under para 10 of the concerned AOI are completely devoid of merit and contain a fabricated narration of fact. Moreover, the said above also do not represent the complete and true narration of attending facts. It is humbly stated herein that while serial number 7 of his letter dated 5/3/25, that is page 150 of the writ petition, the petitioner had forwarded inter alia an acknowledgement of the receipt of his application number so-and-so for being registered as a partnership firm as issued by the Department of Industries and Commerce, Haryana. Subsequently, on 10/3/25, petitioner herein had received a certificate of registration as a partnership firm from the District Register of Firms, Gurgaon, which has been conveyed. So, my lord, regarding registration of partnership also, my lord, we have given.
3.3.8. We are compliant.
So, my lord, whatever was expected of us to comply qua 3.3.8, we have done it. So you can't exercise your power arbitrarily. What for you have exercised this power? You yourself gave us 15 days time from 26 to 25 and we complied with. Now what is the wrong? Merely because you have done a wrong, you cannot go on perpetuating it. Because I'll show you Lord how a third party agency was involved despite the fact that the work was with us. And there is a status quo ante order of this honorable court. That means stay of the termination.
And 1 day after signing the agreement,
Then my lord will kindly come to page number 304. That is the second show cause notice which they have given. Impugn show cause notice. Page 304. Despite all this, now this is the impugn show cause notice pursuant to which they passed the impugn order. Kindly mark the date 9/4/26/25. 7/4/2025 EPC agreement was signed and 2 days thereafter this show cause notice was issued. And most pertinently, my lord, in this show cause notice, there is no reference to show cause notice dated to 26 to 25. And same allegation. Malab, verbatim same allegation. This shows the malafide, malice in law. Absolute non-application of mind, line by line, the same.
First one is
at page number, my lord, 377.
377.
That is dated 26/2/25. And this is the second one, 2 days after signing of the EPC. And EPC was signed after it was vetted by the legal department. EPC agreement was signed after following vetting by the legal department.
Yes.
A project of national importance doesn't mean, my lord, you will, my lord, not follow the rule of law. Absolutely, is not acceptable. Now, my lord, that we have done the work, that will demonstrate. Now, my lord, they say that we have not done anything. I'll refer to one document at page 524, my lord. That is the status of work done by us as on 21/4/25, page 524. Page 524. They say we have not done anything.
Yes.
They say we have not even taken over the site. On top, lordship will notice status of work as on 21/4/25. Development of Sairang railway station on engineering, procurement and construction mode. So, my lord, these are the different heads of work. Kindly see, these are signed by contractors representative, senior superintending engineer works, then executive engineer works. So these are the, my lord, documents to show that we are performing the contract until 21/4/25. And after the show cause notice, my lord. Show cause notice is of 9/4/2005.
These officers are railway officers.
Yes.
This SE action and all.
Action is the executive engineer. SSC is the superintending engineer.
They are under the railway.
Yes.
Railway officer.
Railway officer. My lord, we have made that amendment, my lord.
8.150.
Para 8.1 at page 509. At page 509, that on 21/4/25, prior to issuance of the impugned termination letter dated 5/5/20.
It's okay. It's okay.
Yes. Just amendment, my lord, in
Yes.
support of that. Then, my lord, I was trying to draw your lordship's attention to page number 514. Para 8.6. That in relation to the above, the contents of the paragraphs 4 and 5 of the additional affidavit dated 17/7/25 filed by the petitioner in IA are reiterated and reasserted herein. In doing so, deponent further pleads that as on the date of filing of this affidavit, the extent of the work under Schedule G of the contract agreement, so and so, so and so, so and so, which are complete, are as follows. My lord, after status quo on NT order, this extent of work was done by a third party. And most pertinently, my lord, at page number 480, if your lordship will kindly come to page 480. Now, my lord, lordship has seen from the impugned order that after this show cause notice was issued, we have not reverted back to them. According to them, as per the impugned order. Now, kindly come to page 480. If your lordship should come towards the bottom, third email, Lakshman Mehta, on the left hand side, my lord. Subject: acknowledgement of letter dated 9/4/25, notice under Article 21 of the EPC. We acknowledge the receipt of a letter dated 9/4/25, which was received by us on 17/4/25. This is the show cause notice regarding notice under Swenson. In this regard, we respectfully submit that contract agreement has been signed on 7/4. Accordingly, we request you to kindly provide appointed date as per terms of the EPC agreement, which stipulates that appointed date shall be 15 days from the date of signing of the contract agreement. My lord, this appointed date is very relevant because that will determine the fate of this case. Now, if your lordship will kindly come to in fact, my lord, we have to reply to this because it was the chief engineer who forwarded it on top. And it was forwarded to Milord Lakshman, who is one of the officials of the Milord petitioner joint venture. Now, Milord will kindly come to now what is appointed date, Milord? Lordship would kindly take the petition at page 170. Oh.
170.
170, no? Appointed date is defined. Appointed date means the that date which is of later, that is 15 days from the date of this agreement. B, date on which authority has provided. We are concerned with 1 to 9. 15. A, 15 days from the date of this agreement. This agreement is dated 7/4/25. However, my lord, because in the LOA, we were allowed to proceed with the work straight away, all these things have merged, my lord. How can you blow hot and cold at the same time? On one hand, you are permitted to go ahead with the work without complying with any of the formalities. And on the contrary, my lord,
Agreement was on.
my lord,
Agreement was on
7/4.
7/4.
Yes.
LOA?
6/11/24.
6/11. So according to you have started on
Because we're
issuance of LOA.
Good. No, that's why, my lord, when we moved this writ petition on the first day, our submission was the railway have waived their right. So therefore, my lord, they cannot blow hot and cold. And my lord, para 12, page 15, my lord, we have indicated how much work we have done on the date of filing of the writ petition. Para 12, page 15. These are the extent of work we did, my lord, as on the date of filing of the writ petition. And thereafter also, my lord, even after issuance of the so-called notice, because their own officer has certified on, my lord, 21/4/25. That the extent of work we are doing.
So essentially, you are not interested in the, think only you want that the
No,
payment which the works which you have done.
Tomorrow, my lord, if your lordship allows my writ petition, I'll file a damage suit, heavy damage suit. How I have been dealt with? Secondly, my lord, they must refund my security money and my bank guarantee. Because otherwise, my lord, they will say we'll forfeit it. Now, my lord will kindly come to page number 428. It's part of our reply affidavit, my lord. Because in the impugned order, there is a clear averment that we have not responded to the show cause notice dated 9/4/25.
420.
Page 428, para 7.3 minute. That in specific response to the pleadings contained in paragraph 20, 21, 23, and 26 of the affidavit in opposition, it is humbly submitted that petitioner categorically denies that it had not made any representation whatsoever qua the impugned termination show cause notice dated so and so. It is humbly submitted herein that railway authorities have fraudulently suppressed in their affidavit that on 21/3/25, the petitioner's representative had emailed requested to clarify which was the appointed date as per the railway quasi contract agreement. However, railway authorities arbitrarily omitted to respond to this way. On one hand, they are not responding, and we are being alleged that we have not. Hmm. Now, this is important. However, the railway authorities arbitrarily omitted to respond to this email in order to avoid the expression admission of fact that appointed date under the contract agreement had been preponed owing to the LOA and subsequent activities of the petitioner herein. Therefore, it is humbly submitted that stand of the railway authorities that there was no representation against the show cause notice on the part of the petitioner is repelled, and railway authorities are liable to put to suit. Just to improve their case, my lord, they're doing all this. Then, my lord, one more paragraph, paragraph 8. My lord will kindly come to the middle of that para as averred in paragraph 12. As averred in para 12 of the additional affidavit by this termination, railway authorities had themselves granted 15 days time to the petitioner to submit the original copy of the registered agreement to the railway office. Whereafter on 5/3/25, in due compliance of the aforesaid mandate, the said copy was dispatched to the railway office, and this was admittedly duly received on 7/3/25. Thereafter, the railway consciously executed the contract agreement with the petitioner on 7/4/25. These acts of railways were conscious acts of its duly appointed officials who were authorized for the contractual dealing with the petitioner. Therefore, railway respondent herein, though through successive conscious acts, expressly waived the mandate of execution of the contract agreement by 21/12/24. As such, it was not open to them. This paragraph, with my humble submission, is very, very important. Because it will give you notice of this particular paragraph. In fact, my lord, this paragraph 8 is the whole of our case. How estoppel waiver acquiescence should operate in this case.
Because of the LOA.
Notwithstanding that, my lord, notwithstanding that, pursuant to 26/25 notice, which was rendered otious, we completed the submitted the original JB agreement on, my lord, 5/3, which was acknowledged by them on 7/3. The agreement was signed on 7/4.
Within 15 days.
Within 15 days. Now they are saying you must do it by 21/12, which was originally specified. But then why you permitted to go ahead with the work by the LOA itself?
I think perhaps they are after you because of that registration under the Companies Act.
Yes. And my lord, as I have already explained, I am covered by 18F, my lord, and therefore I am required to comply with, my lord, section 29. Now, my lord,
So according to you, it's not necessary. It's an optional, but it's not mandatorily registered.
yes.
Registration
and
is
no
not.
requirement of registering it before Register of Companies at Shillong. That is what they would like to say. ROC, Register of Company. Now, my lord, please come to para 9, page 400, my lord. Please come to para 400, my lord.
Yes. Page. Page 400.
Page 400. Para 9. This is the first affidavit which railway have filed, my lord. Can you see that the statements made in para 12 of the writ petition are denied by the deponent? In this regard, the deponent begs to state that petitioner could not take over the site even after repeated requests made by later so. A minor work of about 50 m of copying of platform was done by petitioner, no other. Can you see? How they're trying to justify by show of force, Miller. We are working as of 21/4/2025, and they are saying that we could not even take over the site. Now, my lord, the fact that we were working were noticed by the learned single judge, and that is why if your lordship should kindly have the interim order dated 19/5/25. Sorry. Oh, sorry, 27/5/25. Milord will kindly come to para 5, page 3 of that order. There was an interim order. Para 5.
27.
Yes, para 5. Sri Dr. Lanet CGSC has submitted that as per written instruction received, petitioner was not able to take over the site. On a prima facie assessment of the written instruction placed on record, it appears that there is a disparity between the reasons cited in the notice and written instructions. The court itself has, my lord, expressed its view. Now, my lord, NS Gill, Gordon Das Vanji, but the Supreme Court has said, my lord, the action has to be tested on the touchstone of the facts stated in the petition, in the issue not. It cannot be subsequently improved by filing evidence. Then, my lord, in IA 1850 of 25, on 11/6/25, status quo ante order was granted when we all pointed out all these, my lord, illegalities committed by them. Status quo ante, meaning thereby the initial termination order is stayed. In spite of that, my lord, they continued with the work. Now, finally, my lord, if your lordship kindly takes the affidavit of railway in IA 1850 of 25, now they have come up with two reasons. Please have that, my lord, affidavit. Please, 525. Please come to, my lord, page 525. How they are, every time they are improving their case, my lord. Please come to 525. Oh. Oh. I'm sorry. Sorry, my lord. Page 77, I'm sorry, of the IA.
IA.
Yes, 1850. Now, kindly see, my lord, they have now ascribed two reasons that the persons who were communicating with them were not authorized persons, and after status quo ante order, no work was undertaken. Page number 77.
77.
77 of the IA. It's an affidavit filed by the railway. 1850. Okay.
Yes. 77.
Yes.
There's no 77.
My lord, internal page 11 of that affidavit.
No.
My lord, this affidavit is filed by one Vinod Kumar, 23/7/25, son of Amar.
Yes.
Yes. Page 11, my lord, internal. Please come to the, my lord, fifth sentence from the top. This mail was sent by page 11.
Yes.
This mail was sent by Manish Dua, who is not authorized to make any correspondence with the authority. Moreover, the copy of the joint venture agreement attached with this mail was registered before Sub-Registrar Wazirabad. This joint venture is not valid as it was registered before Sub-Registrar of Revenue Department and not before the Sub-Registrar of Companies. Lord, why you signed the EPC then? No, Lord. First of all, this is wrong. I have shown the provisions of the Registration Act. There is no such requirement. Now they say that Manish Dua is the person with whom we are not supposed to represent. Then you have sent the chief engineer send this so-called notice to whom? Not to authorized person. So, my lord, my lord, they are somehow trying to, my lord, cling on to their, my lord, stand that we are right. We are the mighty state. So whatever do we right. Now, my lord, what follows from and moreover, my lord, they have made some payment of the bill also. That your lordships will get. Third party has made payment to us because they were utilizing our materials. Page number 530, my lord, 525. Yes. 525 in the writ petition, my lord. $525 to my lord, 530. These are the bills which was paid by one SC Construction to the petitioner because admittedly, my lord, they used our material. 525, 526, 527, 528. These bills and 529. And my lord, page 530 is the bank statement, wherefrom it will be evident that these amounts were paid to us by SC Construction. Entry number, my lord, that 19 July onwards, my lord, 19 to 29. So these are the payments made. No, my lord, their plea that we have not even taken the side, therefore they were justified in invoking clause 21 of the agreement is absolutely incorrect. Here, my lord, there is absolute, my lord, arbitrariness on the part of the railway authorities in purporting to terminate the contract. Therefore, our humble submission is, my lord, as they have already completed the work to a third party by following a procedure which is not authorized by law. Therefore, lordships will declare that the entire action is fraught with arbitrariness, and therefore, lordships will set aside the termination order. And regarding, my lord, quantification of damages and all, we will, my lord, take a call depending on the outcome of this case. And
So works have been completed by third party.
third party.
It's complete now.
Yes.
No, well.
Then how your PM will inaugurate the work on the day after tomorrow?
I'll submit my lord once.
Okay.
Okay, it's okay. I'll come to you. And what about the
Secondly, performance guarantee and bid security should be
what about the issue on arbitration?
No,
Arbitrability.
Depending upon observation, lordships will made, will go. Actually, my lord, I cannot.
Is it termination itself is not arbitrable?
No, my lord. No, in the facts of this case, when it is so apparent. My lord, what I am saying is, lordship will kindly make a distinction between a case where, my lord, bona fide power of exercise is done and a contract is invoked, then other side saying there is an arbitration clause, then my lord is said, but here is a case, there's a fraud with arbitrariness. They are not sticking to one ground. Every day they are changing.
Okay.
Therefore, lordship will give a declaration that this termination is absolutely bad in law. Based on that, my lord will take a call. And coupled with that, our prayer is, my lord, the performance guarantee and the bid security should be returned to us. In any case, my lord, there are many Supreme Court judgments, my lord, where the Supreme Court has said, my lord, merely because there is an arbitration clause, it does not mean that, my lord, 226 power is not to be exercised. In fact, my lord, famous case,
ABL.
no, ABL.
ABL. Whirlpool and ABL.
ABL. Now, if your lordship would kindly come to paragraph 6, my lord. As already stated, the cancellation is founded solely on the failure of the appellant sample. Non-cooperation, discourteous behavior of the appellant has been alleged in a very general way without specifying what was the non-cooperation and what was the discourtesy shown to the officers of the corporation. Deficiency in sale is also generally stated without particularizing the same. So is the case with the deficiency in maintaining the records. Be that as it may, these are the grounds which form subject matter of the earlier show cause notice, which was not persuaded. In all probability, respondent corporation felt satisfied with the explanation furnished by the appellant. The order of termination is certainly not founded on those grounds, and therefore this aspect need not be pursued further. It may be stated that appellant have volunteered to file statement made on affidavit during the course of the hearing before this court, expressing regret for any incident of departure from the normal behavior and courtesy expected of appellant towards the officials of the respondent corporation, submitting that it might have happened inadvertently, but in future appellant would be more careful and shall show full regard to the visiting officials, etc. So far as the view taken by the High Court that remedy by a recourse to arbitration clause was available to the appellant, and therefore writ petition filed by the appellant was liable to be dismissed is concerned, suffice it to observe that rule of exclusion of re-jurisdiction by availability of an alternative is a rule of discretion and not one of compulsion. In an appropriate case, in spite of availability of alternative remedy, High Court may still exercise its re-jurisdiction at least in 3 situations. So, my lord, these are all well-tested authorities, my lord.
Yes.
My lord, another judgment I will rely, my lord, that 2016, 2016 12 SCC 308.
Yes.
I'll rely on paragraph 17, my lord. The division bench, on the basis of the submission made by the respondent HPCL, found that the reason subsequently invented regarding the FDR in the name of mother and the sister who is married on the date of submission of the application is not correct information, and with regard to FDR amount required to be processed by appellant of the date of the application. Said reason is a new ground which is invented for the purpose of justify cancellation order intimating the cancellation of the candidature of the appellant from the merit list is totally impermissible in law. This statement of law is founded by this court in Gordhan and Manji. The principle has been reiterated in a pattern of cases by this court. On this ground alone, the appeal of the appellant must be allowed, and we order accordingly. Now, here in this case, my lord, lordship has seen from the show cause notice dated 26 to 25 what all are the reasons which they sought to invoke. Now, when, my lord, we complied with, because by 5/3, my lord, we forwarded the original JB agreement. Now, again, my lord, on 9/4/25, after 2 days after signing of the EPC agreement, they have, my lord, come up with exactly the same. So, my lord, Gordhan Judge Bhanji is an authority for the proposition that their action is to be tested based on the original stand. They cannot go on improving their case by filing affidavit subsequently. Now, here in this case, I have shown from the affidavits filed by them how they are trying to improve their stand. In my humble submission, my lord, Gordas Bhansi, MS Gill, these are the authorities for this performance. Therefore, my humble submission is, my lord, it's a fit case where lordships will allow the writ petition.
So if we find that your termination is arbitrary,
Yes.
what relief can we
Well,
grant you?
Arbitration, because my lord, lordships cannot quantify the damage.
Yes.
In that case, we have to go to arbitration or civil court will take a call on it. But prima facie, my lord, there is a violation of Article 4.
We'll see.
And EMD and bank guarantee part, lordships can take a call. But regarding quantum of damage, certainly, my lord, we have not laid any foundation in the petition. For that, we have to take a call before the appropriate forum. But my lord, there is no scope of they permitting us to do the work again.
So, my lord, it is clear, my lord.
Is there any scope of disgorgement?
My lord, now, my lord, I'll explain the, my lord, exact petition.
No, just I'll come to you.
My lord.
Is there any scope of disgorgement?
My lord, I'll show, my lord, they themselves have submitted that, my lord, they are not in a position to, my lord, start the work, my lord.
It's okay.
My lord, now, my lord, first of all, my lord, I will go, my lord, with all respect, my lord, my
Second, the lordship's kind permission.
Yes, yes.
Different.
my lord, my lord, my lord,
Yes.
the submission of my lord, senior my lord, is that this status quo ante, my lord, is, my lord, that the termination order was stayed, my lord. But, my lord, if your lordship kindly come to my,
No, we'll not go into. We're disposing the matter
Well,
finally. Therefore, you come to the merit.
my lord, I'll go
Whatever order has
My lord,
passed.
the status quo ante is, my lord, is from, my lord, 27/5/2025, my lord. Status quo ante as on 27/5/2025, my lord, and termination order is of 5/5/2025.
Why,
The termination order was never stayed, my lord. Number one, my lord. Secondly, my lord, they are saying that, my lord, one SC construction, my lord, is doing the case, doing the work, my lord. My lord, I have documents, my lord, which is not part of record, my lord. This is a GST voucher, my lord, whereby you can show, my lord, that they have sold their equipment to SC construction, my lord.
Yes.
This is the GST voucher, my lord, 22 lakhs, my lord.
Yes.
Of their equipments were sold to, my lord, a contractor who was working nearby, that is SC construction, and, my lord, if he is utilizing his equipments, my lord, that is not our fault, my lord. This is the, my lord, GST vouchers, my lord.
It's okay.
My lord.
They have shown that the equipments and materials,
Exactly, my lord.
it has been used by one SC, the other third party, and then for that they have already got the payment for the materials, equipments and materials.
Yes, my lord.
They have got the payment from this.
SC, my lord, I have underlined SC.
SC construction.
Yes, my lord. They have sold, my lord.
Who is
And, my lord, it is COMT, my lord. First, my lord, kindly see.
what about the works?
Now, my lord, I'll come to whether the termination order is, my lord, given rightly or wrong.
That will. I just wanted to know what about the works? You had said that it was you are ready for inauguration and all.
My lord, that is why, my lord, from the, my lord, they have submitted some document, my lord. My lord, the work is regarding, my lord, the passenger facilities, my lord.
No, before you come to the merit, I just wanted to know the status of the works.
My lord, status order, it is pending, my lord. My lord, the work is in question, my lord, is what is the work, my lord? Exactly, I would say, my lord. Development of Sairang Station on engineering, production and construction EPC mode. My lord. Development of Sairang Station, my lord. This said is also already there, my lord. Now, my lord, the passenger amenities, my lord, are required to be done, my lord. This said is done, my lord. But nothing more than that, my lord. Some, my lord, except the said and, my lord, some other facilities, my lord, nothing has been done. Then that is why, my lord, this contract was floated, my lord, to do the, my lord, development of Sairang Station, my lord, which they could not do, my lord. Now, what is the intention, my lord? That they were supposed to submit the performance guarantee within 30 days of LOA, my lord. And, my lord, thereafter, since they are joint venture, my lord, they are supposed to submit their joint venture, registered joint venture agreement. I am not going by which, my lord, authority they have registered, my lord. Only the registration, my lord. I'll confine my argument, my lord. Whether it is by the under company act, whether by deputy registrar, my lord. Only, my lord, the registered. My lord, it is, my lord, from the date of issuance of LOA, my lord. My lord, they are supposed to give the. Lordship, I have one small comparison, my lord, kindly see, my lord. This is my lord, letter of acceptance and other my lord, up to my lord, letter of my lord, determination order, my lord. Kindly see, my lord, the letter of acceptance, my lord, 6/1/2011, 6/11/2024, my lord. Now, my lord, from this, my lord, now the lordship may kindly come to second case, my lord.
You have annexed this?
My lord, it is a part of the, my lord, document, my lord. Part of the document, my lord. I'll
Which page?
136.
136, my lord.
You just show. From that only.
My lord, I-
Why unnecessary extra? Otherwise also it's so voluminous.
then that is why.
When the papers are annexed, so why unnecessary you are?
My lord, there is voluminous, my lord, that is why, my lord. I will not lordship may kindly see.
I think you are not prepared.
My lord, 136, my lord.
You must have come only for IA.
No, my lord. My
No,
lord,
sir, what I am requesting is, since if these papers are annexed,
my lord.
why I should submit another, I mean, extra?
Kindly, my kind to, my lord, page 137, my lord. 137, my lord. My lord, page 37, my lord.
137.
My lord.
Yes, that LOA.
Hello,
Yes, it's here.
6/11/2024, my lord.
Yes.
And my lord, within, my lord, 30 days of submitting the, my lord, signing, my lord, lordship may kindly come to. My lord. So, my lord, within 30 days of, my lord, signing of this LOA, he is supposed to give the performance guarantee, my lord.
Where is the requirement?
Fine.
Where is the requirement?
My lord, I'll come. At lordship, my page 52, my lord.
52.
My lord.
Writ petition.
My lord.
Section 1, notice. What do you call this?
Page 52, my lord.
What do you call it? This is what? What paper is this?
This is, my lord, this,
RFP.
RFP.
yes,
Yes.
my lord. From, it starts from, my lord, page 41, my lord.
Yes, I've seen it.
My lord, it,
RFP.
my lord, the relevant portion, my lord,
RFP.
page 52, my lord.
Yes.
At, my lord, serial number 18, my lord.
Hmm.
Submission of performance security within 30 days of issue of letter of awardment.
Hmm. Yes.
And, my lord, serial number 19, my lord, signing of agreement.
Hmm.
My lord, signing of agreement within 15 days of submission of performance security.
Yes.
So, my lord, this is given that so that immediately if work can be started, my lord. The letter of acceptance, my lord, itself, it is given, my lord. If you, immediately after the given of the signing of the letter of acceptance, my lord, they can start their work.
Hmm.
So, my lord, this is the logic behind, my lord. Why you should give the performance guarantee, my lord? Because this is the initial requirement, my lord, performance guarantee. Now, my lord, I'll come to the contract agreement, my lord.
So performance security was not
Performance security was given, my lord.
was
Within
given.
30 days.
So agreement was not signed within 15 days.
Agreement was could not be signed, my lord. So, my lord, since the agreement could not sign, my lord,
You have given a notice
we have given a notice. My lord,
to submit all those documents,
my lord,
which
no,
according to them, they have
no, no,
submitted within 15 days.
not, my lord. Lordship may kindly come, my lord, the agreement, my lord.
Yes,
Now, my lord, it starts, my lord, from page 153. Lordship may kindly see.
150.
153.
Yes,
It is, my lord, EPC agreement, my lord.
yes.
153, my lord.
Hmm.
Now, if your lordship may kindly come to the agreement part, my lord, 165, my lord.
Yes.
This is the agreement, my lord, signed between two parties, my lord.
Hmm.
Now, lordship, if your lordship kindly come to the next page, 166. Roman 2 and 3, my lord. (166).
Hmm.
Submit performance security within 30 days of the date of issue of LOA. Execute this agreement within 15 days of submission of performance security. This is the clause of the contract agreement which they have agreed, my lord, while signing.
Yes. Hmm.
Whether, my lord, this clause was fulfilled, my lord. If it is not fulfilled, we are, my lord, entitled to give them a notice, my lord.
Yes.
This is the, my lord, contract agreement they have signed, my lord. This, down below, the two signatures, my lord.
Hmm.
Two signatures, my lord, down below. Their signatures, my lord.
Where?
So they have agreed.
Where it? Where is the signature?
Lordship will find, my lord, in my lord, my IA, my lord. I have given this.
This is a form.
This is a format, my lord. So, my lord, they have agreed, my lord. This agreement they have signed, my lord.
When? When it was signed?
My lord, the agreement was signed on.
7/4/25.
7/4/25.
Yes, my lord. 7/4/25. Agreement was signed, my lord. So, my lord, definitely it is not signed within 15 days of giving performance guarantee, my lord.
It's a unilateral agreement or what?
But, well, bilateral agreement, both of them been signed.
Then who has signed on your behalf?
My lord,
He's an unauthorized person or what?
no, my lord, this signed is, my lord, on behalf of President of India, signed by President of India, Chief Engineer. My lord. So, my lord, this is a violation.
That
my
is
lord.
on 7/4/2025.
Yes, my lord.
You have entered into this EPC agreement.
Yes, my lord.
Both the petitioner and you.
Yes, my lord.
So
My lord, this they
you
have.
could have said, we will not enter into an agreement because it's a violation. We could
But
not enter into
Now,
agreement.
my lord, lordship may kindly come to Article 21, my lord, of this contract agreement. Article 21, my lord.
Yes, where it is?
Whether, my lord, we can give a notice, my lord, under Article 21.
Where it is?
I'll come. Article 21 at page 277.
277. Termination.
Well, may I read, my lord?
Yes.
Save as otherwise provided in this agreement, in the event that any of the defaults specified below shall have occurred and contractor fails to cure the default within the cure period set forth below, or where no cure period is specified, then within a cure period of 60 days, the contractor shall be deemed to be in default of this agreement, the contractor default, unless the default has occurred as a result of the breach of the agreement, my lord, by the authority or due to force measure. The defaults referred to herein shall include. My lord, lordship may kindly come to page 779. 279, my lord, 279.
Yes.
279.
Close.
My lord, S, my lord.
X.
S.
S.
S. Last one, my lord.
The contractor commits a default in
Default in
complying with
complying
any
with
other
the
project
provision of this
agreement,
agreement.
such a default
The provision of agreement,
causes
my
a
lord, he should
material
sign
adverse.
this agreement within 15 days of giving performance guarantee.
on
So,
the
my lord,
project.
under this clause, my lord, we have given the contract, the
Notice of
notice
termination.
and my lord.
It is too large an area to
My lord, the logic behind my lord,
the contractor commits a default in complying with any other provision of this agreement if such a default causes a material adverse effect on the project or on the
my lord, the project, my lord, 100 and some days, my lord, they have delayed, my lord. So, my lord, project got delayed, my lord. My lord, my specific submission is, my lord, everything finished, my lord. Only except, my lord, the shade is also there, my lord. But the other amenities, my lord, development of station, my lord, my lord, that was for that only, my lord, the tender was floated, my lord, and which they could not do, my lord. Now, my lord, this is a JV, my lord. Two persons are there, my lord, joint venture agreement, my lord, two companies or two entities, my lord. Somehow, for some reason, my lord, they could not sign the joint venture agreement. For that, my lord, it got delayed, my lord. Now, my lord, can we wait, my lord? Can we wait, my lord? My lord, after 78 years of independence, my lord, this is, my lord, joined to the, my lord, the rail map of India, my lord. Everything is finished, my lord. Commissioner of Railway Safety has given its certificate, my lord. I have, on oath, my lord, I have stated, my lord. Only the station, my lord, to the originating station in Mizoram, my lord, that was supposed to be my lord. That is a small work, my lord. So, my lord, around, my lord, how many crores, my lord? Thousands of crores, my lord, we have invested, my lord. The railway, my lord. Invested, my lord. For 70 crores, my lord, we are waiting, my lord. And, my lord, why? They could not give the agreement, joint venture agreement. And the logic is that, my lord, we have given immediately after giving the joint venture agreement, we have signed the contract agreement. So we have to wait until you give the joint venture agreement. So it may be 100 days, it may be 300 days, it may be 600 days. We have to wait up to that, my lord. And, my lord, I'll submit one judgment, my lord, where, my lord, it is relating to infrastructure project, my lord. The Honorable Supreme Court, what the Honorable Supreme Court has said, my lord. My lord, this is the guy. My lord, Lordship may kindly come to para 21, my lord.
NG project.
Since 21, para 21, my lord. I have mentioned the paras, my lord. It's the paras which are I am relying, my lord. Para 21, since the construction of road is an infrastructure project and keeping in view the intent of the legislature that the infrastructure project should not be stayed, the High Court would have been well advised to hold its hand to stay the construction of infrastructure projects. Such provision should be kept in view even by the writ court while exercising its jurisdiction under Article 226 of the Constitution, my lord. Now, my lord, I will come, my lord, one more para, my lord, para 14. Para 14, my lord.
Why you are relying this?
My lord, I am showing, my lord, that this is an infrastructure project, my lord.
So
And, my lord,
nobody is disputing it.
my lord, my lord, I bow down, my lord. My lord, the thing is this, my lord, it is, my lord, going to be open, my lord. After, my lord, 78 years of independence.
Who is stopping you?
For 70 crores, my lord, we are waiting, my lord.
Who is stopping?
My lord, there is no stay order, my lord. My lord, staying the my lord, termination order, my lord. But the status quo ante from, my lord, 27, my lord. That is what, my lord.
So that's why I'm asking, who is, are you working on it?
No, my lord.
Have you engaged somebody?
No, my lord. my lord, we are specifically, my lord, submitted in my miscase, my lord. My lord, deep status quo ante may be lifted, my lord.
No, no, we're disposing of the entire matter now.
My lord. So, my lord, so that, my lord, we can finish the work, my lord. My lord, as per my information, it is, my lord, required to, my lord, going to be opened by this month, my lord. And only some, my lord, we may be allowed to do this, some work so that, my lord, it can be opened. My lord.
This month. How can you finish within this month?
Well, everything is finished, my lord.
Everything finished, go ahead, what's there? Who is stopping
My
the
lord,
inauguration?
This is, my lord, originating station, my lord. This is the originating station.
You said everything is finished. You are going to inaugurate it.
Yes.
Inaugurate it.
My lord, the passenger facilities.
How
my lord,
can you finish this within if it's going within this month?
my
How
lord,
you can finish this work within this 4, 5,
my lord,
10, 15 days?
my lord,
Can you finish the work?
there are, my lord, instances, my lord, where, my lord, when, my lord,
See,
flood water, my
what
lord,
was the time period of, completion period?
by next year,
Huh?
by next year, my lord, 700 some days, my lord.
Huh?
Yes, my lord.
So
But-
how can you
but
finish
2
within 4
years, my
days?
lord.
2 years?
Yes, ma'am.
This is for 2 years.
Yes, ma'am.
So how it is related to your inauguration?
My lord, no, my lord, at least some facilities, my lord, passenger will come, my lord, to, my lord.
The completion period of the project is development is for 2 years. More than 700 is more than 2 years.
My lord, from, my lord, 2024, my lord, it is, my lord, going on, my lord.
Now, what I am asking is, when you are relating to the mentioning about the inauguration,
Because
what I am saying, you are going to inaugurate it by this month. Now, this year, the work requires to be completed within, it will take 2 years.
2 years, my lord.
How
That
it's-
means, my lord, February 2026, my lord.
Huh?
February 2026, my lord.
Huh?
So, my lord, more than 50% of our work will be completed, my lord. Should have been completed by now.
So when you are going to inaugurate? This month you are saying?
My lord, yes, my lord. My specific instruction, my lord.
So you inaugurate it, no?
My lord,
Without completion of-
my lord, we could not even started the work, my lord.
Can you complete within this
My lord,
20 days?
my lord, some minimum work we will have to, my lord, do so that the passenger can come to get the trains, my
The
lord.
work is to be completed, it will require 2 years, right, to complete this. And you have issued the LO in November, right? It was supposed to be completed in when? 26.
Yes, ma'am.
If it is 2 years, 26, 11.
Hello.
Not February,
Okay.
11 only. Right? Now, how this inauguration come in
My
between?
lord, there is only the said, my lord. As per my
See, I'll tell you, you have issued the LO in 2011, 2024.
my lord.
It is to be completed by within 2 years, which is 11, November 2026.
Hmm.
You are supposed to inaugurate the project this month.
Hmm.
How you reconcile this?
My lord, reconcile this, my lord. We want to do it completed as soon as possible, my lord. At least, my lord, by 6 months, my lord. Some
can you
facilities,
finish?
some facilities, they will complete, my lord. Now, my lord, we do not accept the said, my lord. There is no facilities, my lord. Accept the said, my lord.
Can you complete within 20 days?
My lord, we can at least, my lord, the basic amenities, my lord, we can provide, my lord. Basic amenities, my lord, like the flooring and other things, my lord. And, my lord, I have shown from the contract agreement, my lord, clause of the contract agreement, my lord, we have, my lord, terminated it by following the terms of the contract.
When
Madam?
you have terminated?
My lord, 5,
5,
my lord.
November, December, January, February. 6 months, 7 months, 6 months. No, why I'm not convinced is why.
My lord, lordship is absolutely correct. How can we complete the work of 2 years within 1 month? Lordship is absolutely correct, my lord. There is no doubt, my lord. But, my lord, my humble submission is, my lord, we would have, my lord, done, my lord, this is 6 months already elapsed, my lord. My lord,
So what is your decision now?
6 months we would
Since the work has not been, started or done anything, are you going to inaugurate it?
The status quo ante, my lord, as on 20.
Forget about that. Are you going to, if we allow it to go ahead, Can you complete or are you going to inaugurate this month?
My specific submission on this point is that, my lord, we'll be able to give the minimum work which is required for only opening the, my lord, to start the, my lord, the trains, my lord, from the station, my lord, we can do it, my lord. Minimum facilities, my lord. And, my lord, we will complete it in the minute. And, my lord, I have shown, my lord, they have sold their equipments, my lord. My lord, we have taken many.
Forget about them. What I'm saying is this development works, it will take 2 years, right? So you have decided to inaugurate this year, I mean this month.
This one.
Suppose today, if we allow, go ahead with the work.
My lord.
Can you done it?
Yes, my lord.
Okay.
Yes, my lord, I will bring.
How it's possible?
My lord, I will bring one affidavit, my lord, by tomorrow, my lord.
Saying what?
We'll be doing at least the minimum work so that it can be inaugurated. And, my lord, I do not have the exact date, my lord. It is, my lord.
In fact, they are not interested in the work any longer.
No, my lord. How
No longer they are interested to work.
we have invested thousands of crores, my lord. Lordship, can you, Lordship, imagine that only for
Arre,
stand-
sir, what I'm saying is their British is no longer interested in the work. They are aggrieved by your arbitrary action. That is what your case.
Yes, my lord. But
They'll take it, I mean, they'll approach the whatever damage, whatever arbitration, they'll go for it.
my lord,
But that's why I'm saying we are considering the matter, but then this inauguration part, I am not convinced. How? Just because of this, you will not be able to inaugurate. When you have plotted that, issued the tender, providing 2 years period of completion, and you have decided to, before the completion, within 6 months, you decided to inaugurate, open the thing, project.
my lord, I and my friend, my lord, both are here, my lord. What we are given to understand, my lord, it is going to be inaugurated shortly, my lord.
Do it.
Yes, my lord. My lord, that is not my submission, my lord. It is what we have given to understand, my lord. And, my lord, for that, my lord, the status quo ante is, my lord, the only hurdle, my lord. We wanted to complete some of the work by 6 months,
Status
my
quo
lord.
is not harder.
And, my lord, we can complete, my lord, everywhere we have seen, my lord, the 100% work may not be completed, my lord. My lord, I am doing a, my lord.
Okay, that's all.
My lord, one example I will want to give, my lord. Volasodia Bridge, my lord, which was inaugurated in 2018, my lord. It was, my lord, the full work was done only in 2021, my lord.
Okay.
But inaugurated in 18, my lord, by the Prime Minister, my lord.
Okay.
That's reply with only 2 short points, if I may.
Yes.
That's my learned senior colleague. He made an argument that even if they had to wait for 600 days, then it would have been our fault if the contract was signed bilateral. Going by Lordship's question, which was put to my learned senior colleague, this is not an agreement which has been signed solely by the petitioner. As my learned senior, whom I was assisting, has demonstrated, on 26th of February, they came up with a show cause notice, and we have complied with the show cause notice. It is pursuant to that, that the agreement has come to be signed. And 2 days after the agreement is signed, they have come up with the same exact show cause notice. And Milords will kindly note throughout the pleadings as well of the railways in this case, there is not a single mention in which they have traversed this argument of 26 to 25. They have.
Have you submitted the registration?
Yes,
what they are saying that your registration is by the register under the Companies Act. What you have submitted is by registration by the industry department, something like that.
So we are a registered partnership, which in the latest affidavit in reply that is filed before your lordship in the writ petition, the certificate of registration is annexed. It is not disputed that we are a registered partnership firm. They are also in agreement. Their issue is that we are registered. The agreement is registered by the Revenue Authority, which is the law. But the sub-registrar is the only authority in the country of India under the Registration Act who can register an agreement. And they are disputing that, that under the Registration Act, we have gone under Section 29 and gotten our JV agreement registered by the sub-registrar Wazirabad.
But what they are saying is it should be by the ROC, Register of Companies.
Which is impossible, an ROC or a Registrar of Partnerships cannot possibly register an agreement in our country. It is hit by provisions of the Registration Act 1908.
Yes.
Under the Registration Act, Section 29.
And otherwise, it's optional. It's not compulsory.
Yes, it is optional. And number two, Milords, their own RFP, clause 3.3.8, which is already placed, Milords, at page 82. What it provides is two things. Number one, the JV entity should be registered either with the ROC or the Register of Partnerships, which we are. And number two, the original copy of the joint venture agreement should be submitted.
I suppose today, I mean, if we all that this is the termination was in not accordance with the terms or it's arbitrary. So what relief we can provide?
Yes, Milords, only in relation to that. But Milords had put a very pertinent question to both sides, that if disgorgement is possible. I have taken instructions on this specifically from my clients. They are not averse to continuing the works. The only issue is the contract value, Milords. Milords will kindly see at page 495, I'll not bother Milords with the record. They have admitted that some works which are very important to ensure safety of running trains are completed. My learned senior colleague has not disputed that. He's saying that trains are running. So
No,
he
not
admitted.
running. Not running. It is, my lord, the Commissioner of Railway Safety, my lord, has given the certificate for
Permission.
running, permission.
Milords,
But my lord, unless and until will all facilities, my lord, so at least my lord, minimum facilities are not given, my lord. It is,
trains are running there. Milords. We have placed photos also. There are trains which are running through the station.
that is not, my lord, for commercial purpose. My lord,
Now, see,
some-
Milords, that is the trains are running. The issue is, Milords, see, from our side, Milords will humbly kindly take into account. From our side, we are not averse to continuing the works. The only issue is the contract value, Milords. They, unfortunately, throughout the course of these proceedings, they have not come clean before this honorable court and admitted that this is the amount of contract value which we have completed during the course of these proceedings. The moment they do that, Milords, the moment the contract value is adjusted, and we are told that you please now confine yourself to working for this amount of contract value. We are prepared to work, Milords. We are prepared to work. We have only said that we have shown that table, Milords. My learned senior has shown that table. In respect of those works under Schedule G of the contract, we cannot now again do the works, Milords, because they're already complete. So the contract value for those works.
They have already completed.
Yes, Milords. Those are completed.
But you, by you or
By somebody else, Milords. During the course of these.
he said nobody has
Yes,
touched
they're
that.
completed.
violation of the, my lord, order of the honorable court, my lord. How can we, my lord,
Yes, yes. They have done
That
it.
is what they are saying.
my lord,
There's a violation.
Yes, yes. And we
You
have
have
said
not,
this
you have
categorically.
not complied, I mean, abide by the order of this
So
court.
they have, my lord, they have not filed a contempt.
Just tell us factually,
Hello.
because we'll be disposing finally the matter. What they have said is that somebody third party has already completed the work.
No, my lord. Absolutely no. My lord.
Nobody has worked on it.
No, my lord.
Nothing
At
has
least
been
that
done.
part, my lord, the,
Nothing has been done.
my lord, they, at least
No one is working on it.
them, my lord, they have said they have started some work, my lord. After them, my lord, the contract work has not been started. My lord. As per my instruction, my lord. That is, my lord, if my lord, I admit that we are working, my lord, it will be directly contempt, my lord.
No, no.
My lord,
For a time being, we're not taking any action at here. You tell us factually.
to my lord, submit as per the instruction given to me, my lord. And my specific instruction that, my lord, the contract agreement, the work of the contract agreement has not been touched, my lord. Lordship may kindly come. to
What
this-
works you have touched?
Nothing. Other work, my lord.
You are not doing anything.
My lord, this is only regarding the station, my lord. Other work, my lord, the line, and other work, my lord, they were given to some other contractor.
They have said somebody is working, almost all the works are completed. That's why you are going to have that inauguration and opening the thing.
My lord, kindly see the photographs, my lord.
So that's
My
what I'm
lord,
saying.
kindly see the photographs, my lord. They have
We-
taken next, my lord.
we have-
Even the floors are not completed, my lord. I have seen, my lord. The floors is been not complete. My
By whom?
Yes.
By them or by somebody else?
lord. If they have not done the work and, my lord, there is a status quo order, my lord, then how can it be completed? my lord?
I assure you, we're not initiating any contempt.
No, my lord,
So tell us tell us the actuality. What is the actual on ground?
My lord, I cannot go beyond, my lord. My lord, I have not visited that place, my lord. I have to, my lord, submit on behalf on the, my lord, text on the, my lord, on the paper, my lord. And
No, I would like to know the factual thing, actually what is
no,
happening.
my lord, it is, my lord, yet to be done.
Are you sure?
Yes.
What about these photographs? From where? These photographs are from where?
My lord, this, kindly see, is it completion, my lord?
It's not a completion by the time,
Well-
but somebody is working on it.
It may be some other work, my lord. It is only 70 crores, my lord. what can be done, my lord, for 70 crores, my lord? A
Okay.
station, my lord,
Then,
70 crores. my lord.
what about the arbitration?
My lord, arbitration clause is there, my lord.
Wow, clause is there. How in the facts of this case? What is your submission on that?
My lord, if they have any claim, my lord, there is provision for arbitration, my lord. They can file very well my lord, a claim petition before as per the my lord, clause of the contract before the general manager. And if they do not appoint my lord arbitrator, then under section 11 of our arbitration act, they can come before this honorable court
So,
for appointment of an arbitrator.
Whom you are schooling? How they appoint arbitrators and have to be initiated? Then
Lordship,
I'm asking you this writ petition.
Lordship is asking
When
me-
there is the arbitration clause,
I'm not schooling you, Lordship. Lordship,
no, I'm not saying so. But as if you are schooling, you are schooling,
Think of that.
you are schooling somebody.
I cannot even think of
How the arbitration proceeding has to be initiated, how the arbitrator has to be appointed.
if I have
What I am asking you is a writ petition. It's a contract matter, termination of contract. So when there is a arbitration clause, what do you say on this?
Lordship, what will Lordship will decide, my lord, will follow that, my lord.
Obviously,
My lord,
you have to follow.
Yes,
This is
sir.
something, we're not on that.
my lord.
I'm asking a specific question. Are you,
My lord, Lordship may kindly come to, I'll go to the, my lord, the arbitration clause, my lord, directly, my lord.
no, we understand there's an arbitration clause. Are these issues, the issues which they have raised against the termination, is it arbitrable?
Yes, my lord.
Can this be a subject matter of arbitration? In a
Because
simple
they,
word.
my lord, they have suffered loss, my lord, for the fault of the railway, my lord.
Otherwise, writ petition is maintainable against the termination.
If, my lord, it is mala fide against the provision of the contract provision.
Hmm.
If it is mala fide and even against the provision of the contract,
Not malafide, what they are saying, the arbitrary.
against the arbitrary. Well, I have shown from the provision of the contract agreement, Mala, that it is as per the clause of the
I'm
contract.
trying to, indicate the point which you are supposed to raise against this writ petition. But why I should make you
No.
more wiser?
Mala, Lordship is Mala clearly indicating that whether they can go for arbitration when the grievances raised by them can be sorted out through arbitration or not, Mala. Probably that is the query of your Lordship, Mala.
Not query,
Mala,
it's an issue.
issue, Mala. Yes, Mala, that can be resolved through arbitration, Mala. My humble submission is that, Mala, and Mala, that is a specific point raised by Mala in my case, Mala, that the provision is there, Mala. If they want, Mala, they can go for arbitration.
Okay.
That's my only response to this one submission regarding arbitration is that if we have to arbitrate, because our submission is that for the works that we have done from December till the point of termination, for that we have not been paid. So as my learned senior had also submitted during our arguments, for the works that we have done from December till the time of termination, we have not been paid by the railways. So that would
We
be
don't know whether you have worked or not.
Yes.
Although you have some papers, it will be difficult.
I'm
At best, we may say, suppose if we allow your once it is terminated, it goes along everything.
I'm grateful, Millards.
Right.
That is my prayer, Millards, that
Every right will be merged with those termination.
certainly,
The consequential,
certainly, I'm obliged.
once it is terminated.
Yes,
Right.
obliged. And that, Millards, in that
We'll see that.
in that line, Millards, because that would be a disputed question of fact. Therefore, Millards, I'm praying that if at all we would have to go to arbitration, it would be on that point. We are not raising that before this honorable court, Millards. It is not a part of our pleadings. We are not contesting that we have worked from day X to day Y.
No, what I'm saying is that termination itself cannot be a subject
That is
matter
our
of
submission.
arbitration.
Very humbly, Millards,
I'm asking,
it is not, Millards. If in our humble submission, it is not.
termination itself, can it be a issue, subject matter of arbitration?
No is our humble submission. In our humble submission, no. We have
Yes, Mala.
You are yes.
Yes, Mala, because
Obviously.
Mala, because
You'll say yes, you'll say no.
why, Mala, I am giving the reason, Mala. I'm submitting the reason.
It's okay. Anything else?
If, Mala, it is not arbitrary, Mala. Mala, if it is not
Arbitrable.
Mala, then how can they are entitled for the compensation, Mala? If it is rightly given, Mala, then they are entitled for the compensation.
No, that is different. That is something different. What I'm saying is the termination itself can be a subject matter of arbitration.
Yes.
That is what-
Yes. That's understand.
Because on that,
I'll look into it.
yes, because there's a written submission that we had prepared,
Yes.
just to assist this honorable
Yes.
court. We have
No, it's
provided-
better. It's better also.
Yes,
It's-
I'm
it's-
giving a copy to my learned senior colleague as well, sir.
You also file your return
Mine.
by tomorrow.
Mine.
By tomorrow.
Mine.
See, whatever points you would like to.
Mine.
Your submission is that forget about the reopening, I mean, the inauguration and all that. And the huge project, I mean, project of national interest is done. How your termination is in accordance with the law.
No.
Let's use.
Fine.
All right. Keep it here. Hard Mr. Ken Chode, senior counsel assisted by
Say Gautam.
learned counsel for the petition, and also heard Mr.
Z Goswami.
G. Goswami. Learned CJC,
No, madam. Railway caption.
Standing Council Railway, NF Railway, and AK Datta, learned CJC, 4 respondents. Hearing concluded, judgment reserved.
Very grateful.
Because you have expressed urgency, you submit your written argument by tomorrow.
By tomorrow.
That's
so that
we'll
we can
file a
finish it up.
compilation of judgments, but that's only that. We have submitted a written submission.
Only 3, why so many judgments?
Only 3.
You just, if you want to give that on that only, whether the termination
Yes.
can
Yeah,
be arbitrable.
certainly. Only on
Yeah.
that point we'll give judgment.
Just
Yeah.
only one
Only one.
judgment.
Very well. By tomorrow, looks. By tomorrow.
By tomorrow.
Grateful.
We'll not touch it today. By
Okay.
tomorrow I'll start.
Very grateful.
Judgment.
Mission.
8 days, Your Lordship.
Yes.
This pertains to a tender work
Yes.
and tender work of 2015, Lordship.
Okay.
The tender notice, Lordship, would be pleased to find at page 13, Lordship. Page 13 of my rate petition. Here, Lordship, a tender was floated for various categories. The categories are down below at page 13, Lordship. First is market for boulder, stone, sand, soil, etc.
Yes.
And for minimum tender value was
This
six-
for
seven-
inviting tender list for the year 2000 from so and so to collect tax oblique
Tax.
toll parking tax as per the
petitioners.
marketing place. How is this is market name of the
No,
marketplace?
Yes.
Why this is?
That was the mistake in the tender notice. So the Lordship, the petitioner job is.
It's
to
basically to collect tax only. Why this name of the market of boulders, stone and
Yes,
soil, etc.
absolutely, Lordship. Incorrect.
Okay, no,
So
no.
In,
So you will have to collect tax toll, parking tax from the market of market.
no, not market, Lordship. That is the mistake, the incorrect things they have placed, Lordship. My job was. to
Tender
collect-
itself was wrong.
Tender itself was wrong in placing the things, Lordship, because Lordship would be pleased to the second category. Parking fees of bicycle, fish market, market of this, market of rickshaw, milk market, is all parking fees. Then Lordship, next page, market of bamboo and engine boat, municipal market, category number 9, that 10, parking fees of motor cars. So all categories. So my specific job was to collect toll tax from the vehicle which were carrying stones and soil, etc. from the mining areas. That was my job, Lordship. So accordingly, the work order has been allotted to me on page 22, Lordship. Is the allotment of the work order for a period of 1 year.
Pursuant to the tender.
Pursuant to this tender.
Yes,
Lordship.
work of market
Yes.
oblique parking fees of market.
My duty is to collect only parking fees from the from the carrying
Okay,
vehicles
for
yes,
2 years now,
for 1 year, Lordship.
1 year, then?
For 1 year, Lordship.
Hmm.
I've been allotted and the tender value was, my value was accepted 11 lakhs 80,000.
Yes.
That was the for 1 year.
Hmm.
Now this work order was issued on 19/3/2015, Lordship.
Hmm.
19/3/15 till 1/9/2000 2015, Lordship. I was under operation of the mining areas. I was under operation that I was collecting the toll tax. In between, Lordship is aware that the monsoon fully this March to August is fully monsoon area. So I could not collect the revenue as expected, Lordship. That
So-
was one of the factor. I have that also I have mentioned in my petition. Now, what has happened on 1/9, Lordship? Basically, this the stone, sand, river, the stone, sand, chips, and gravels are to collect from the river. After the extraction from the river, the vehicle is to carry them, and from my job is to collect from those vehicles, toll tax from those vehicles. So there are basically two mahals within the Barbeta municipal area, wherein my job was entrusted, Lordship. Two mahals are, one is Saulkhwa Mahal, another is Nakhanda Mahal. There are two mahals where these mining operations were carried out. Now, Lordship, may please to come page 25 of the petition, page 25. Lordship is there at page 25 of the petition.
What is that?
Page 25. That is Annex 3.
What is that?
That is the suspension of one of the mining area, Lordship. So that is
But
very
not your mining, not yours.
no, yes, that
Not yours.
Lordship. This falls under my jurisdiction from where this vehicle
Page.
page 25, Lordship.
Hmm.
Lordship is there at page 25.
Yes.
Yes, may I read the contents, Lordship?
Hmm.
Suspension of mining operation in regard to NKD, that is Nakhanda Mining Contract Area 2014-21. This office letter so and so. With reference to above, you are hereby directed to suspend mining operation of Nakhanda Mining Contract Area and stop any dispatch of mineral from the concession area till your default is cleared and interest so and so you have failed to deposit so and so from due date. You are hereby shown as to initiate contract regarding Nakhanda mining contract area. You should not be terminated along with forfeiture of security deposit money in the event of continuation of default a period of 30 days from the date of order of suspension. Please note that you are liable to pay the dues for suspension period, that is from 1/9/2015. Your reply shows should reach office undersigned within 10 days. And this order was passed by the Divisional Forest Appeals. So 1/9/2015, this now conducted two malls from where this mining operation was carried out. That one is this Nakhanda and other is Saulkhwa. So the vehicle could not be carried. Vehicle could not carry further minerals from these areas, Lordship. So that directly affected my contract work, Lordship. And that is how, Lordship, I could not make as per the terms of the work order, Lordship. However, Lordship, I have paid more than 6,87,000. Sorry, 8,37,000. Lordship.
You are seeking relaxation.
Yes, I was seeking on the following grounds. I was seeking relaxation. Thereafter,
And they have rejected. How much
Yes.
how much you have to pay?
I have to pay now, according to them, another near about 4 lakhs.
You pay?
That is the inconvenience, Lordship, because I had suffered, I had to pay my whole other employees, Lordship. And I had to suffer huge loss because of the suspension of this mining area, Lordship. That is how I sought for relaxation, for remission of the rest of this
Yes.
and Lordship. Wide resolution, that is page 46, wide resolution dated 21/6/2016. They have, in earlier occasion, I have filed in one petition, and thereafter it was placed by them that.
Because they have taken a resolution rejecting
yes.
your claim,
Yes.
your
Lordship.
grievance.
That-
Therefore, it has become infructuous.
Yes.
So therefore, you are filing this writ petition.
Yes, Lordship.
Why
That
not?
is-
Why not convince you have to pay? Yes.
Lordship, yeah, Lordship, the specific purpose for my contract was to collect toll tax from the.
Whatever you have agreed to have that thing with a certain condition to pay the kiss, what do we call it?
Kiss money.
Kiss money.
Lordship, that closer.
Your only ground is that you could not collect it, operate it properly because of the
because of the forest ban, Lordship. The forest, because of the forest ban, I could not collect, Lordship. And I could not complete the work. I could not complete the rest of my contract work. And that has affected in collection, and that is.
yes. What about how the forest has banned it?
I'm not representing forest lordship, but in the tender document lordship, the area is given lordship. All municipal area of Borbeta. There is no mention about particular lordship of all.
Mining area.
Yes, there's nothing. Only one.
From where you are collecting, it should be within the municipal, Borbeta municipal area.
If your Lordship have a look at page 13 again, Lordship, all specification. If your Lordship kindly come to page 13.
Under what provision you are asking remission or the exemption or relaxation? Is there any relaxation? Is there any notification
Nothing.
or role?
Taking the jurisdiction of this on.
No. You are asking from the authorities of relaxation to pay the balance amount of KIST.
Under the circumstance, not
Nothing.
exactly being
On human consideration.
Yes, Lordship, showing the no.
So
Lordship, here, Lordship, page 13 again, Lordship.
I've understood.
Page 13, every work order, every categories has been entrusted for a specific purpose. And my specific purpose was.
How much you are not able to pay?
I can hardly pay, Lordship, now at this because I have incurred huge loss because of this, Lordship. I can hardly pay 50,000, Lordship.
How much amount is due?
How much due?
It's not.
According to work order, it was
3 lakhs
instructed to deposit amount 93 days. First installment.
36.
Huh?
Page 36.
36.
Page 36.
36. How much amount to be deposited?
3,95,000.
How much you have deposited earlier? 3 lakhs.
No. I have deposited total 8,37,000. 8,37,000, Lordship. Out of 11 lakhs, 80 rupees, I have deposited.
So what is your ground? Why you cannot consider it?
We have considered lot. We rejected.
No, how you have rejected it? So,
Lordship, I seek for this remission of the amount under the aforesaid circumstances because it is absolutely act of God that the whole season was monsoon season from March to, that is admitted fact, Lordship. I have made category, I could not execute the work because of the climatic condition. That apart, Lordship, that ban is also here, another book, Lordship. So that is how even by it is my bona fideness that out of this 11 lakhs, I have paid 70% Lordship, 8,37,000 I have already paid.
you pay another rest of the time. So you have been given on pursuant to the tender only. Hard, that's all.
Lordship.
That's all.
Lordship may kindly look into the circumstance. Under what circumstance I was defaulted in paying that.
Okay.
That's it.
Hard MS. That's all.
Lordship, I pray for relaxation. At least
We cannot. It's a terms of the tender. You have agreed. You have accepted the tender. You have to pay. No error.
Okay.
That too, you are collecting a tax toll from others.
that is in terms of that I have to.
That's why, in terms of that, you have to pay deposit since you have already collected, right?
That is my.
Cannot.
That is my fact, Lordship.
That's
I
what-
could not collect it.
What can we do? Hard,
And the
we'll see. Hard MS.
please show me.
This of Land Council for the petitioner and also heard Mr.
Goswami.
and Goswami, Land State Council for all the respondents. Next time, by filing this writ petition, the petitioner has to challenge the resolution dated 21/06/2016 passed by the Borpeta Municipal Board, whereby the application for relaxation of the payment of outstanding amount of the petitioner has been rejected. Please do. Briefly put, the petitioner was allotted. When it was settled,
Yes.
with the, what is that word?
Collection of toll tax from the farm fight vehicle of.
Settlement.
So work order is page 22 lots.
Where it is?
Page 22.
22. No, the pursuant to the NIT issued by the Barpeta, no, issued NIT dated 11/03/2015. For the market of stone, sand, boulder, soil, etc. of Borpeta Municipal Board for the period of 2015 to 16. The petitioner was settled with the said work by work order dated 19/03/2015 in consideration of rupees 11,80,001. Please stop. The petitioner on acceptance of the said work order, acceptance of work order, started to execute by collecting taxes, by collecting tax oblique toll, within say municipal
Toll,
ah,
collecting toll.
toll within the Barpeta municipal area. List of. It is the contention of the petitioner that an amount of rupees 8,57,000. 37 or 57? 57.
57.
57,000 has already been deposited. Out of the total consideration of rupees 11,80,001. Huh? Next paragraph. Well, the petitioner was working. Was executing the settlement for the. This is Nalakanda mining area.
Nakhanda, yes.
Nakhanda mining
Nakhanda.
area, mining contract area.
No, Lordship, it is entire municipal area, Lordship, but that particular area was closed.
No, I said
Yes.
Nakhanda mining contract area.
With lordship indulgence, just want to clarify this point. The
Nakhanda is one of the area, mining area within the municipal.
Yes.
Yes.
Two areas within there are only.
Municipal area.
There are only two areas in the municipal. One is Saulkhwa and is Nakanda. From where these articles like boulders and soil can be extracted, mining work can be carried out, and my source of collecting tax are based on these two malls only.
Okay, we'll record that.
Nowhere mentioned, Lordship. There is not
But it's
mentioned.
in my
I'll
petition.
record his submission, her submission only. What is it? While the petitioner was executing the settlement. No, the by the order dated 01/09/2015, issued by the Division Forest Officer, North Kamrup District, Rangya, where the operation in respect of Nakhanda mining contract area, which was under the contract of, which is under the Mahalda, namely Sri Gunajit Nath, was stopped, was suspended. It is submitted that it is contended that petitioner collects toll tax, toll of the market of boulder stone, sand, etc. within the Barpeta municipal area. And the market of the petitioner is based on two mahals, Nakhanda Mahal and Saulkhwa Mahal. SAULKHOUA. Since the two mahals were put on suspension, were suspended, the petitioner, being the municipal toll collector of both the mahals, the settlement could not be, the work could not be continued, rather had to be stopped, although the petitioner has invested a huge amount of money. It is contended that due to suspension of the stop of the two mahals, the settlement allotted to the petitioner under the Barpeta Municipal Board for a period of 1 year could not be continued. Now, having faced with such situation, the petitioner has represented to the respondent authorities for relaxation or what we call remission or relaxation.
Lordship.
Remission cannot be, because
That's
relaxation of the further payment of the required consideration. Mr. The respondent authorities by order dated, by resolution dated the same, huh? At page 45, huh? 21/06/2023 has rejected the claim of the rejected the grievance of the petitioner. Rejected the claim of the petitioner for relaxation of the payment of the outstanding amount. Mr. M.S. T. Som, learned counsel by the petitioner, submits that since the petitioner, since the settlement was in respect of two mahals, namely those two mahals, huh? Nakanda and Salokwa mahals. I said, since the two mahals, huh? The settlement in favor of the petitioner was for two mahals, and the two mahals having been
one.
suspended by the, huh?
One has been suspended.
Okay. Other two, it's continued.
That one was continuing, but that was not with the sand and soil. That was only soil.
No, and then you should, due to suspension of the mahal, one mahal, from where the petitioner was collecting toll, the petitioner could not continue the settlement as he was not able to collect the toll from the said, which has caused huge loss to the petitioner. List of. And then whatever the monsoon season,
Yes. From its settlement order was passed on 19/3/2015. So that is March to up to August is fully monsoon area.
that apart, due to
Heavy monsoon.
heavy monsoon, and due to monsoon season, the petitioner could not properly work with the settlement. Even then, the petitioner has already deposited 8,57,000 out of the total consideration of rupees 11 lakhs. That's something. 11 cents. Huh? Therefore, considering the above facts, the respondent authorities ought to have considered the claim of the petitioner for relaxation of payment of outstanding amount. However, the respondent authorities has arbitrarily rejected the claim, ignoring the facts and circumstances of the facts and circumstances attended in the matter. Next para. Yes, what is your submission?
Affidavit lordship, final affidavit lordship.
Yes.
One mahal is closed lordship, baki others are working lordship. And in the tender notice, there is no mention about any mahal lordship. This entire Borpeta area.
Mr. So-and-so, learned counsel for the petition submits that the suspension was in respect of only one mahal, namely what? Nakanda. And there was no suspension of any other mahals.
Okay.
From where, and the petitioner was settled with the work for entire
Municipal area.
Borpeta municipal area, from where he had collected tolls, list of. The petitioner has accepted the settlement which was issued by an order dated, work order dated 1903-2015 for a total consideration of rupees 11,80,001. Therefore, please stop. And he submits that therefore he is duty bound to deposit the remaining amount of rupees. How much?
Outstanding lordship,
Yes,
3,95,000.
3,95,000
Global.
to the responding authorities.
With indulgence.
He submits that there is no rules or regulations under which the petitioner could make a claim for relaxation of the consideration amount of consideration in as per the work order, which was really accepted by the petitioner. And as such, the petitioner and the writ petition, and as such, there is no merit in the writ petition, and the same is liable to be dismissed. Yes.
One more lordship, I cannot go the beyond lordship because clause 10, page 14 lordship of the tender notice. There is another tender for 17 lakhs for collecting parking fees of motor cars. That is already another there. So I cannot go beyond.
This you cannot say anything.
Lordship, that
Now
has
it's
to be
very difficult.
mentioned.
No,
I cannot go to everywhere and collect all.
no, we cannot say. We cannot say.
Vehicle lordship.
Whatever is there, you have accepted as per the work order
No, this
or a consideration of so and so.
my submission may be recorded that I cannot.
No, we'll not record everything. Why I should record? Which is not necessary. This is a tender condition. Pursuant the tender, you have been settled with the wall
Yes.
or for a consideration of
No,
particular amount.
they want to say that.
No, you don't want. I mean, it's your
Lordship,
maybe your ill luck.
Lordship, they want to say that I can go and collect from the.
Consider the submission of land concept of the parties also pay materials and liquid. We'll continue. We'll continue. I'll dictate in the chamber. We'll complete it. Writ petition dismissed.
Lordship, may I?
We'll grant you, we'll grant you 2 months' time to deposit.
Yes, Lordship. Some relax.
Not possible.
Obliged, Lordship.
May please.
Yes.
The matter relates to my lord, no confidence motion against the chairman of Dergaon Municipal Board, my lord. Lord, so we find the impugned minutes at page 43. Page 43, my lord. The impugned minutes dated 19/12/2024.
43.
43, my lord. Lordship got it, my lord. This is my lord, minutes of meeting dated 9/12/2024 at 3 p.m. of Dergaon Municipal Board regarding no confidence motion. Next, Lordship may skip that part. Today's meeting is presided over by the chairman, Dergaon Municipal Board, Srimati Rupali Bora. In the meeting, the chairman informed the house that today's meeting is held on no confidence motion against the chairman and requested the members to express their views in that regard. The vice chairman requested the chairman to inform the house, if any, on the reason of no confidence, motion of no confidence moved against the chairman on 19/11/2024. And more particularly, these are the allegations, my lord, against the petitioner who was the, my lord, the chairman of the municipal board. Lordship will find the point number 3, my lord. Chairman informed the meeting that no money under SOPD scheme has been returned back yet, and though it has been decided to construct a public toilet at Dergaon Sariali at a cost of rupees 76 lakhs, but due to anomalies in selecting the proper place of construction, the construction work would be executed. The members of ward number 10 lamented that the chairman given works in ward number 9, but no allowed to work in ward number 10. 9 members of the municipal board opined in favor of no confidence motion against the chairman and accepted the resolution of no confidence. So, my lord, here Lordship will find the 9 members, my lord, have my lord opined, my lord, in favor of no confidence motions, and that was accepted. My lord, against that impugned resolutions, my lord, I have submitted a representation on 12/12/2024 that Lordship will find page 47. This, my lord, I have submitted before the District Commissioner Golaghat, my lord. With due respect, I beg to state that in the meeting held on 9/12/2024 at the office of the Dergaon Municipal Board, discussion took place on various aspects of the municipal board and also discussed the issue of no confidence against the chairman. In that meeting, no any member had moved no confidence motion against me, and there can be no question of adopting any resolution of no confidence motion. But the members created a chaotic situations in the meeting, and the members immediately prepared a minute of the meeting and forced me to sign the same. Finding no way out, I was compelled to put my signature in the said minutes. 9 members of the municipal board opined in favor of no confidence motion against the chairman and accepted the resolution of no confidence has been recorded. In fact, no such proposal was proposed or passed. It is mentioned that as per rules, the minutes of the meeting of the municipal board has to be recorded in the standing proceeding book of the board, and the minutes of the proceeding book must be signed by the approver. But minutes of the meeting dated 9/12/2024 has not been recorded in the proceeding book of the board, and I have not signed in the proceeding book of the board as chairman. Therefore, I request, like to inform you that the so-called no confidence motion is illegal and not valid in the eye of law. Therefore, I request your honor not to approve any resolution of the meeting dated 9/12/24 and not to take any consequential steps without me to perform. And subsequently, my lord, the municipal board held another meeting on 11/12/2024. That lordship will find page 49. In that meeting, my lord, the sum and substance of the meeting is that the 9 members, my lord, except me, my lord, have elected one, my lord, new chairpersons of the municipal board. Here, that, my lord, I have pointed out only one thing, my lord, page 51. Page 51, my lord.
Saying well.
Point-
Saying what?
Point 4, the voting process has started and on the basis of voting, Mrs. Madhumita Bora, member of ward number 5, has been unanimously elected as chairman. Here, my lord, the voting has been, my lord, conducted to select a new chairman, my lord. So far, in the impugned resolution, my lord, there is no voting. Here, my lord, my argument is only, my lord, 2 points, my lord, that the procedure prescribed, my lord, under the Assam Municipal Act, my lord, that has been violated, my lord, and the procedure prescribed under the Municipal Act is a mandatory procedure. Any departures, my lord, from the mandatory procedure is vitiates the, my lord, entire proceeding. Your lordship will find 47, section, my lord, 47.
47?
47 of the book, my lord, Municipal Act. Page 43, my lord, in that book,
Page 43.
my lord,
Municipal Act.
my lord.
Page 43. 40?
3, my lord.
Yes.
Section
Minutes
40,
of the proceedings.
minutes of the proceeding, my lord. Minutes of the proceeding of all meetings of the board shall be entered in a book to be kept for the purpose and shall be signed by the president of the meeting and shall be published in such manner as may be prescribed and shall at all reasonable times and without charges be open to the inspections of the taxpayer. So, my lord, here the
Minutes of the proceedings of all the meetings of the board shall be entered in a book to be kept for the purpose and shall be signed by the
president of
president
the
of the
meeting.
meeting and shall be published in such manner as may. This is a normal meeting.
No, my lord,
No
all
con-
meetings, my lord. Here,
Huh?
here lordship will find all meetings. The word used is all.
Including no confidence.
Yes, my lord,
Huh?
including no confidence, my lord.
So what is the procedure for no confidence?
Yes, that lordship will find it, section 28, page 32.
$28.
My lord. $28, 2, my lord. Page 32. An elected chairman or vice chairman
May be removed from the
removed
office
his
by
office
resolution of board
resolutions of the
in
board
favor of which
of which more than half of the whole number of chairpersons shall have given their votes at a meeting specifically convened for the purpose. Your lordship will find the word uses votes, my lord. And now lordship will find 45A.
The state government, after giving an opportunity to explain, may remove the chairman by sparing information of person. It can be removed by no confidence.
Yes, my lord.
Maybe from the office by resolution of board in favor of more than half of the whole number of have given their votes at a meeting especially convened for the purpose. Then subsection 3, state government can
This
also
is, my lord, regarding the, my lord, allegations, they can be, my lord, if government, my lord, remove that part, my lord. Now lordship will find again, my lord, 47.3, that, my lord, that part is important. Page 44. Section 47.3.
section
47.3, my lord. 47 starts at page 43.
Yes.
Lordship got it 47-3.
The minutes shall be laid before the next meeting of the board for confirmation and shall also be signed at such meeting by President.
Here,
No, no, this is regarding meetings only,
No,
no,
my
no,
lord.
no.
This is regarding, my lord, as regards to, my lord, 47-1. So all here 47-1, it has been written as all.
No, no, even if it's all, it is all other meetings.
No, my lord.
Not
It's
except the
include, my lord, it's include, my lord, the no confidence meeting, this is special meeting. My lord.
Oh,
Because the word used is, my lord, minutes of the proceeding of all meetings of the board.
no, confidence is something different, confidence motion.
But, my lord, there is no anyone.
Meetings for confidence motion is something different. Yes. Yes.
And the, my lord, subsection 3 of section 47, my lord, stipulates that the in the next meeting, my lord, the earlier resolutions have to be, my lord, placed and that the confirmation is required.
If it is in other methods.
No, including, my lord, no
In the
confidence.
meeting, normal meeting of the board.
No, my lord, not as my humble submission is that it is not
It
including,
includes
my
the
lord,
no confidence motion.
including no confidence. Because the word, my lord, is used is minutes of
Was
the-
there any notice of no confidence?
Yes, that part is, my lord, I am not objecting.
There was.
My
There was a
lord,
meeting
yes,
for,
yes,
there was a
yes.
notice for,
Requisition and notice also there.
notice was there,
Yes.
then resolution.
Yes.
That's all.
But, my lord, the procedure prescribed.
How
my
many
lord,
members were there?
10. Total
Out
10.
of 10, 9 against,
against.
voted against you.
Yes.
Huh?
But the procedure prescribed, my lord, that has not been followed. Because the minutes of the meeting, my lord, that has not been
What is
recorded.
the procedure? Except, forget about procedure. 47, I have heard you.
My lord.
You, according to you, the meetings includes the no confidence motion meeting.
Yes.
Therefore, it has to be followed.
Yes.
Yes. Is there any other provisions for procedure for no confidence?
No, my lord, only 28, my lord, it has been prescribed, my lord, as regards, and the only thing is that the, my lord, the vice chairman, my lord, whereas the, my lord, proceedings, no confidence proceeding against the chairman, the vice chairman, my lord, ought to have been presided over. Here, my lord, I have been presided over. That part I will not object in, my lord, because since, my lord, I have, my lord,
Only section 47.
section 47 and, my lord, 28, no votes.
Okay.
Because in the, my lord, subsequent meeting, there was a vote, my lord. And the regarding, my lord, 47-3, confirmation that, my lord, the subsequent proceedings, my lord, 11, 12, 24, that, my lord, minus of the meeting, my lord, I have annexed, my lord. There is no any whisper in that meeting, my lord, whether the
Voting, in the voting, what is that?
page 49, my lord, the subsequent meeting, my lord, after the, my lord, no confidence motions, that meeting was held on 11, 12, 2024, my lord. Page 49.
49. First was page 47.
Yes, page 47 is the, no, my lord, page 43
No.
is the, my lord, impugned minus, my lord. That was dated 9/12.
Okay, you are challenging this.
Yes, and now lordship will find page 49. Next meeting of the, my lord, board, that is on 11/12.
No, this was for appointment of.
Yes, that's why, my lord. That's why, my lord, 47-3, my lord, states that in the subsequent meeting of the board, the earlier proceedings must be placed and that confirmation is required. But here, my lord, in the 11/12 meeting, there is no any whisper.
But this 49 is for selection of,
Yes, that's,
election of new chairman.
yes, that's true, my lord. But here, my lord,
According to you, as per section 47,
3.
meeting has to be recorded in the book,
Yes.
proceeding book.
Yes. And signatures of the presided, my lord,
Presiding president has to be
required.
there. And it has to be ratified or it has to be approved in a subsequent meeting as per section 47.3. That's all.
Yes, my lord, now.
Accordingly, that has been violated.
Yes, now lordship will find the affidavit filed by the, my lord, respondent number 3, my lord.
Who is respondent number 3?
The additional district commissioner, my lord.
Okay.
The affidavit has been filed, my lord.
So there is no appeal provision as such.
Yes.
No appeal.
This on honorable for under 20 6, my lord.
Yes, yes.
Lordship will find the affidavit filed by the respondent number 3, my lord.
Hmm.
Page 60. Running page, my lord.
60.
60, my lord. 60 আছে, হ্যাঁ।
Yes.
Para 9, my lord.
Hmm.
With regard to the affirmations made in paragraph 10 of the petition, the deponent begs to state that the petitioner has submitted a written representation dated 12/12/2024 before the deponent, which was forwarded to the EO, Dergaon Municipal Board. It is to be stated that a report has been submitted by EO, Dergaon Municipal Board, file letter number so and so dated 13/12/2024. The matter is under consideration in the District Commissioner Office, Golaghat, and soon an order will be passed in this regard.
Hmm.
Whether, my lord, the record will reveal whether any order has been passed on the, my lord, representation submitted by me, my lord. And secondly, lordship will find at page 62, paragraph number 14.
Hmm. Duly understood, the proceedings of a special meeting dated 9 has been entered in the.
Now, it has been entered in the proceeding at a letter on, my lord.
However, this chairman did not.
However, the
sign
chairman did not sign in the proceeding. It is to be
It is to
stated
be
special meeting dated is a type in a plain paper. In that paper, chairman has signed in this place provided for her seal. My lord, here, my lord, whether they have admitted that the proceedings of the minutes of the impugned meeting dated 9/12/2024 has been recorded, my lord, in the proceeding book at a letter stage, my lord. And my lord, whether they have asked me to put my signatures to follow the procedure, that part, my lord, is silent, my lord. So this, my humble submission, this, my lord, this letter part is, my lord, afterthought, and they have manipulated that record, my lord. Because on that day, my lord, when the resolutions was adopted, and even on the next day also, there was no record of the proceedings of the impugned resolutions in the proceeding book. And in the page 16, my lord, it has been stated that in the last line, it is to be stated that the election of the chairman has not been approved by the government. That is elections of the chairman of the new chairman. Now, lordship will find the affidavit filed by the, my lord, respondent number 7, 8, 9, 11, 14, and 15, my lord.
Page.
Please, my lord, in my copy, my lord, it has been written as 57 to 64.
Who is 5 and 6?
7, 8, 9, 11, 14, and 15.
5, 6, and 7.
Yes. No,
Five-
no, no. 5, 6, and 7, no, my lord.
5
7, 8, 9, 11, 14, and 15. Torn by my lord Madhumita Bora.
Only 5 and 6 are available. Oh, sorry.
Another affidavit.
77.
7, 8.
77. Page 77.
Lordship will find paragraph 8.
77. 7, 8, 9, 10, 11, 15.
Yes, my lord. Paragraph 8, my lord. Married, my lord. In that regard, lordship got it, my lord. In regard to the paragraph number 13 of the writ petition filed by the petitioner, the deponent states that the petitioner, knowing fully well that the meeting was held for no confidence motion against her, participated and presided in the meeting, and the resolution was passed against her. After losing in the no confidence motion, the assail was made to the procedure of the meeting. Everyone known that the meeting was called for passing a resolution either in favor of or against the no confidence motions of the petitioner. The ultimate result was valid even if the requirement or conditions are not performed. So ultimate, indirectly they have indirectly, my lord, they have admitted that the procedure prescribed, my lord, in the, my lord, act that has not been followed, though the ultimate result is valid, my lord. My lord, the records, my lord, this lordship may peruse that records, whether the minutes of the meeting has been recorded, my lord, properly, and the whether, my lord, there is any, my lord, dates wherein the, my lord, minutes of the meeting has been entered in the proceedings book, my lord. And so far the voting part is concerned, lordship will may kindly that part also, my lord,
Voting.
voting.
It
When-
shows that this is just an opinion. Opinion had been expressed against you
But my
in
lord,
favor of the
yeah,
no
but my lord,
confidence.
that's why, my lord.
According to you, it has to be, it's by voting only.
Yes, because my lord, this page 51, my lord.
Yes.
The subsequent meeting, when the, my lord, new chairman has been elected, my lord, the voting procedure has been adopted, my lord.
Hmm.
But in my lord, no confidence resolutions, my
Vice
lord.
President requests the chairman in the meeting. Nine members offered in favor of no confidence against the chairman. That's why I'm asking, where is there's no specific provision for voting, I mean procedure for no confidence.
My lord, only 28, my lord. Yes,
Can be removed, that's all.
Yes.
There's no provision.
No. That's why, my
And no
lord,
procedure.
procedures, my
There
lord.
must be some rules. Election rules, selection,
No,
election
lord,
rules.
it is not there, my lord.
Is there any procedure prescribed under the rules?
Yes, Lordship, it is section 28 for no confidence motion
Hmm.
and section 41 for election of the new chairman or vice chairman if
Section?
vacant. Section 41.
41.
Yes. So far, my learned friend stated regarding the minutes for selection of new president after vacancy of the earlier president by way of no confidence, Lordship. It is, Lordship.
President or chairman? Chairman.
Yes, chairman, Lordship. It is sorry, Lordship. It is chairman. Now, Lordship, in page 49.
Just wait.
Yes. English version. English version.
Filling of vacancy of chairman, and if any chairman is not Yes.
Your lordship, before start, my lord, I just pointed out one thing, my lord. Section 47A, page 42. This is, my lord, immediately after, my lord, the 44, 45.
47A.
45A.
All questions of at the meeting of the board shall be determined the majority of votes of the commissioners. Hmm. Hmm.
That, my lord, all questions, my lord, in a meeting. That means, my lord, including the no confidence motion. But in 44, my lord, the procedure as regards when the no confidence is against the chairman and against the vice chairman has been prescribed, my lord. Who will have to, my lord, preside over in the meeting of no confidence, my lord. 44.
Hmm.
In 45, my lord, all questions in a meeting of the board shall be determined by majority of votes of the commissioners present.
Hmm.
That is missing in the impugned resolutions, my lord.
Hmm.
That's So my submission is that, my lord, since there is a complete departure from the mandatory provisions, my lord, so the entire proceedings and the subsequent actions taken based on the, my lord, impugned proceedings, initiates, my lord, that the, my lord, the impugned order is viable itself.
Yes.
Lord, sir. Section 28 categorically stated for removal of the chairman and vice chairman. Accordingly, your lordship, that the when 9/12/2024, lordship, the is the minutes of that meeting, lordship, and that minutes was duly signed by the petitioner, lordship, and this meeting was held for the sole purpose of discussion about the no confidence motion. It was, lordship, it was this meeting was called by the petitioner herself, lordship, and the notice, the notice was given by her and categorically stated that it is page 69, lordship, running page 69, lordship. It is the notice, lordship. Affidavit, lordship, filed by the
69.
69, lordship, affidavit that was filed by the respondent 7 to 15, lordship.
Executive officer Dargaon initiate action for non-convening.
69, lordship.
Hmm.
Lordship got it. It's a notice, lordship.
I'm
9/12.
sending you the letter along with the minutes of the meeting regarding no convening motion against.
It may be changed, lordship.
Yeah,
Annex
just need to
R2, lordship.
present.
Annex R2s.
Hmm.
It's a R2.
Hmm.
Annex R2.
Annexure D,
No, lordship, I think it is,
page 69. Affidavit filed by
lordship, affidavit filed by respondent 7, 8, 9, 11, 14 and 15, lordship.
You have a different pagination.
Similar.
69 is wrong. Annexure R
R2.
R3.
is page 89.
Page 89. This is the notice, lordship. Notice issued by the petitioner, sole purpose of no confidence motion, lordship.
A meeting has been convened at the Dargaon Center regarding member, presence of all members, including the office. This is by the petitioner.
Yes, lordship. Petitioner.
Notice is not to be moved by the, motion is not to be moved by the
Earlier, it was moved. Earlier, it was moved by the 9th ward commissioner.
where it is.
Yes. It is, your lordship will find
Page 85, R1.
Yes, lordship, it is lordship.
Page 89, 85.
85 is your lordship.
On the basis of this,
Yes, lordship.
this notice was issued.
Yes,
Same day.
same date. Notice was issued by her.
It's okay. There's not on that. What he's saying that
Yes,
there may be a confidence motion was moved,
lordship.
but it has to be as per section 7, because it's a meeting where it has to be recorded in the book and signed by the president of the
Yes,
meeting.
Lordship, I'm going to.
And even if meeting is conducted for no confidence motion, it has to be by vote,
No. Now,
according to him.
yes, Lordship. Now, Lordship, section 28. I would like
Yes.
to read the section 28.
Yes.
A elected chairman or vice chairman may be removed from his office by a resolution of the board, in favor of which more than half of the whole number of commissioners shall have given their votes in a meeting specially convened for the purpose. Now, Lordship, half of the-
Resolution says that offine in favor of the no confidence. It
Yes.
has not said voted in favor of the
Yes,
confidence
it's
motion.
a resolution, Lord.
Resolution doesn't speak of voting.
Yes, Lord.
It requires the vote,
Yes.
voting.
No, Lordship.
Section 29, removed by vote. What is this? Resolution of the vote.
There is no specific
Resolution, you read it
yes,
again.
resolution. It is a
Resolution of what?
resolution of the
Vote.
board in favor. No,
Yes.
not vote. Not vote. Just I would like to say. Resolution of the board in favor of which not more than half of the whole numbers of commissioners shall have given their votes at a meeting specially convened for the purpose. This 28. Now, Lordship. Now, Lordship.
You have not read. Be removed from his office by resolution of board in favor of which more than half of the whole number of commissioners
Yes.
shall have given their votes at a meeting especially convened for the purpose.
Yes. So, here, Lordship, the vote, it means now when the vote, when the position for vote will come, if the vote will come, half of the it means more than half of the whole numbers of commissioners shall give their votes. If the votes will come, first it is a resolution. There in this meeting, Lordship, the minutes of the meeting dated 9/12/2024 itself categorically stated that there is no objection against the no confidence motion. It is all the members are in favor of the no confidence motion. Thereby resolution taken. All the 9 members except the chairman, all the 9 members are were in favor of the no confidence.
Whole number of their commissioners.
Yes, they are commissioners, and they are the commissioners. Total this Dergaon Municipality Board is constituted 10 commissioners. Total 10 ward, each ward 1 commissioner, 10 commissioners also. And 9 commissioners were in favor of the no confidence motion.
So voting is not required.
Yes.
Why? It clearly says shall have given their votes at a meeting especially convened for their purpose.
No, but it is stated that the resolution of the board in favor.
Yes, resolution will be preceded by the vote.
Yes. No.
Your resolution of the resolution says that opine in favor of. It's not said voted.
Now, Lordship, Yes. Now, Lordship, kindly see.
You want that this court to read down this vote?
Which one, Lordship?
Read down the vote. Reading down the vote.
No, Lordship, it is 20, section 28.
Says that by more than half of the whole number of members shall have given their votes at a meeting, especially convent of body, by a resolution of board.
It is like that, Lordship. An elected chairman or vice chairman may be removed from his office by a resolution of the board in favor of which not more than half of the whole members of commissioners shall have
Number of
given-
commissioners.
Yes, members of the commissioners
Shall have given their votes.
votes at a meeting specially conveyed for the purpose. In the resolution, in the minutes, it is categorically stated that 9 member is in favor of the no confidence motion.
Without voting.
Voting, Lordship, in this section, there is no specific criteria is not given.
What
for
do you,
voting.
what do you mean by that's why I'm saying you want us to read it down. The words votes have to be read it down.
Yes, the word vote is there, Lordship.
Then
In 28, Lordship. In 28, vote is there, but it is not provided the specific provisions how the vote how the vote will taken. It was not specifically given, Lordship. But so far, Lordship, the language is that, Lordship. This language is
okay, next. So according to you, voting is not required.
Yes, Lordship.
Although there is a mention of a requirement of voting.
Vote-
Because out of 10 members, 9 members were there. Are you saying so?
Yes.
So therefore, if it's not only more than a half, it's 9 members, therefore voting is not required.
Yes.
Are you trying to say so?
Yes.
Are you trying to say so?
Yes. I'm trying. Although in this section or any other any rules of the Assam Municipal Act, Lordship, there is no specific criteria for voting.
But it's
regards to
provides,
Section 28.
may not be procedure, may not be there, rule may not be there, but it provides as voting.
Voting.
Voting is required. Voting is required.
Lordship.
Next.
Lordship.
I have understood what you want to say.
Lordship.
What do you want to submit?
Yes. Page 44, Lordship.
Yes. Long time.
9 members.
Oh, fine.
It is yes, Lordship.
9 members of the municipal board are fine in favor of.
Yes, no
Is it-
confidence motion.
They could have used voted in favor.
Now, Lordship, next line.
Matter would have been.
Next paragraph, Lordship. The members in favor of
This is a translated copy.
yes,
You read this. This may be voted
yes. Now,
instead
Lordship,
of fine.
no.
In my lord, particular my lord, it has been written at mot pohon kore, my lord.
Huh?
Mot pohon kore.
Huh?
That means express their opinion.
Huh?
Mot pohon kore.
Not voted.
No. পৌৰপতিৰ অনাস্থা প্ৰস্তাৱৰ
Lordship,
সপক্ষে
here-
পৌৰসভাৰ 9 জন সদস্যই মত পোষণ কৰে আৰু অনাস্থা প্ৰস্তাৱ গৃহীত কৰা হয়। মত
It
পোষণ
is
কৰে।
opinion and
Yes,
expression.
Now,
Expression.
Lordship, another paragraph is there. It is in Assamese vernacular, Lordship. সপক্ষে থকা সদস্যসকল, those members, those commissioners in favor of the no confidence motion. It means it is likely to be vote, Lordship.
No, no.
Because সপক্ষে থকা সদস্যসকল, so and so, it is stated.
In Okhomia, what is voting is what?
Uh,
Is there any particular word?
The voting is, it is word vote.
মতদান
Yes.
More than to
Motodan.
it's Hindi. It's Hindi.
Yes. It is motodan. In Assamese, it is mot pukhon kore.
No, no, no.
Same.
No, sir.
No, it is same. It is, say, motodan. It means my opinions was given.
But my lord,
It is mot pukhon kore.
in the my lord subsequent minus my lord, that is on my lord 11, 12. ইয়াৰ
Yes.
পিছত ভোটদান প্ৰক্ৰিয়া আৰম্ভ হয় আৰু ভোটদানৰ ভিত্তিত
ভোটদান।
সৰ্বসন্মতি ভোটদান
It is Lord.
Vote done কয়।
regarding
It's- it's
selection of
vote
my lord new chairperson. It has been written as
So it's called vote
Yes,
done.
Lordship.
Yes.
Yeah, I will go
Vote
to
done.
no,
Vote done.
Lordship,
done.
Lordship. I will go to page number 25 later on. Page number 52 later on. Lordship.
No time.
No, Lordship. Now, Lordship. Page number 52 is specific. It is under section 41.
Your friends, your seniors are waiting for you. Please.
Lordship, kindly see here in Assamese vernacular.
No, I've understood you that page section 28.
The section.
Come to
28
section 48.
No, now.
Come to section 47. Sorry.
I will come to 46, but 46.
Please come now.
No,
That's
no.
the issue is there only.
46, Lordship. Here, the page 46. It is Assamese vernacular. It is specifically stated that mot pukhon kore. It means the vote was given by the commissioners.
Are you saying this
Yes.
translation is wrong
Yes,
translation?
Wrong. Wrong.
Oh, my lord.
Specifically, it is subsequent.
That's why my lord, I have pointed out in the subsequent meeting. Here it is in the vernacular my lord.
Yes.
It has been written at ইয়াৰ পিছত ভোটদান প্ৰক্ৰিয়া আৰম্ভ হয়।
Now,
মত পোষণ আৰু ভোটদান প্ৰক্ৰিয়া my lord.
Mot pukon is opinion and expression.
now,
ভোটদান is different.
Now, Lordship, section 41. Before section 41.
Yes.
41 is categorically stated about election.
Hmm.
It is categorically stated about election, therefore vote.
Hmm.
It is categorically in case of vacancy of the office of the chairman and the vice chairman. It is 41(2), subsection 2. And in case of vacancy of the office of the vice chairman, the chairman shall call a meeting so as to complete the election. It is election. Therefore, specific voting is required.
For selection or appointment of
Of
new chairman.
Yes, new chairman. It is section 41.
Hmm.
Section 41, subsection 2, categorically stated about election. But section 28 is not categorically stated about the process of voting. It is only stated that the resolution.
And the voting.
For resolution, voting. Here, Lordship, in favor of the resolution, they given their vote. They given their mot pukhon. It means mot done.
Primacy
Yes.
voting has to be preceded
No,
by
Lordship,
resolution.
If
resolution has to be
if-
preceded by voting.
If there are two ways,
That is the meaning.
two opinions, if there are two
It's not
opinions-
simple you have to read entire sentence.
Yes, if Lordship, I do admit it, 28 is that, the word is voting is there. But Lordship, in 41 is categorically stated election.
There's the election. This is no confidence removal.
Yes.
For new election, for new chairman, there will be election.
Now Lordship,
In case of vacancy.
here in the Assamese vernacular, it is categorically
understood.
stated. It is categorically stated that the vote was given by the members. Vote were given. But it is the precedent, Lordship. Every no confidence motion, I can submit the minutes of several no confidence motion, which is before your Lordship, in several cases, such type of language is there.
Mhm.
It is the contention.
Where it is.
Kindly-
You don't know if
kindly
several
pick-
cases
yes,
is
Lordship.
done,
Yes,
it's
Lordship.
not before us.
Yes, kindly pick the matter in the next week. I will submit. There are 3-4 cases in my hand also.
Place it,
Yes,
was
I
there,
will
it's
submit.
listed for
I will
hearing.
I will place
No, it's good, no
Yes.
admission.
admission.
Okay, next week. Heard Mr. So-and-so, learned counsel for the petitioner. And also heard Mr.
J.K. Goswami.
A.K.
J.K.
J.K. Goswami, London State Council, and all. Give your name, huh? Matters. Heard the matters
Pardon, my lord. I am obliged, my lord.
at length. On the prayer of Mr. J.K. Goswami, State Council. For the respondents, let the matter be listed after a week for further hearing.
Obliged.
I didn't know.
I'm not going to the hearing again.
Yes.
Yes,
Malada, the petitioner is having a plot of land in North Guwahati, where Malada, the front portion is his business premises. He has a plant where for retesting
who
of
is the restaurant?
government is for the other side.
Yes, government, ready?
They have filed an affidavit.
No, filing an affidavit. Who is appearing?
One of the councils are in the some other.
Huh?
The councils maybe in the some other court.
Urgency is there.
The only thing is that my factory is closed.
It's okay.
Factory
It's
is-
already closed. Heard Mr. P.K. Roy Chaudhary, Land Council for the petitioner. Not appears for the respondents. Then he said, pleadings are completed. List the matter after 2 weeks. 2 weeks.
For admission. Malada.
Yes, admission.
Okay, but by filing this writ petition, the petitioner have challenged the press or tender notice also. On the last occasion, we have taken time to obtain the instructions as regards the appeal filed by them. We have received the instruction and accordingly filed rejoinder also. It can be heard today, Lordship.
Huh?
Can be heard today, Lordship.
You have filed
We filed the rejoinder and it's on record, Lordship.
you have filed.
We have already filed out.
Please, your Lordship. Lordship, Senior Counsel Mr. Biridas is appearing in this matter, Lordship. Lordship, he is on legs in court number 10. Lordship, can you pass it over for the time?
No, today is not possible then. Some other day.
Lordship, can you fix it, Lordship?
Is the interim order in your favor?
Order is there.
It's okay. Then on the prayer of the council for the parties, let this matter be listed after a week.
Lordship,
After a week.
next week, any hearing date? Tuesday,
We have
perhaps?
fixed so many matters.
Any date, Thursday, Lordship? Because
Not-
Lordship, only 3 months are left, Lordship,
For what?
for the tender period, Lordship. So,
Next after 2 weeks.
Lordship,
Before the vacation. Not next week. Next to next week.
Before vacation.
Lordship, before vacation, any date may be given.
Huh.
As per Lordship.
25th.
Lordship. We are obliged, Lordship.
And 6.
Ocean Singh. What is the matter?
Wait, Lordship, this case we have challenged the inaction of the forest official in search and seizure of my property. I am the owner of launching Cookfall at Arunachal Pradesh. They have seized my property. They have raided my property at Cookfall industry at Arunachal Pradesh, stating that it comes under Lekhapani Forest Range, Assam. But in this case, Arunachal Pradesh has also filed their affidavit stating that it is under Arunachal Pradesh. All the documents have been obtained from Arunachal Pradesh,
Yeah.
and the raid was without the permission of the Arunachal Pradesh government and even the judicial court there. Now in this case today, Lordship, yes, forest has still that last 4 occasions they have.
Lordship, you are filing an affidavit today. Will serve him a copy today within half an hour. Lordship.
In this
They are saying that it falls under Arunachal Pradesh.
They are saying
How can you enforce on it?
because they have that coal area
There
inside
are-
the reserve forest. That's
Huh?
we have inside the reserve forest. Lordship.
Which that will be taken care of by the Arunachal,
We have daughters in
not by you, not by you.
Arunachal Pradesh has filed an affidavit and they have stated that it is.
No, that's what I'm saying.
Let our affidavit come on record, Lordship, because we have annexed everything regarding this Everman's neighbor petition, Lordship.
Is it disputed?
They are saying that it's
The industry, it's located in Arunachal and the license was issued by the district administration.
Okay.
Everything is under Arunachal Pradesh.
and we are saying that it's inside the reserve forest of Lekhapani, Lordship.
Maybe you may say so, but then if it is in the Arunachal Pradesh, where is your authority? Who are you?
let the affidavit come on record, Lordship.
My lord, they
Very crucial for that.
even went and charged my residence, my lord, which without any charge warrant, without.
They will take care of that. If we
Let-
find that if it falls under Arunachal Pradesh,
Let ours and come on record, Lordship.
the
Next week.
consequence will follow.
Yes, Lordship.
Be ready for that.
Because,
Be ready for that. Okay, heard Mr. B.D. Leonard, Senior Counsel assisted by
Thank you.
Ms. Learned Counsel for the petition. The state of Arunachal Pradesh, the respondent number, where's Arunachal? Respondent number?
affidavit has been filed by the respondent number
Respondent number 9, 8,
7 and 8.
7, 8 and
Nine.
9,
7 and 8 has filed the affidavit.
Arunachal Pradesh.
Your lordship.
No, respondents 7, 8 and 9 within Brigade authorities in Arunachal Pradesh have filed their affidavit in
Your-
opposition. Huh?
Your lordship may kindly look at paragraph number 50.
No, it's okay, we're not taking up today, he's seeking time. Huh?
4 or 5 opportunities already.
On the prayer of Mr.
Aragoga.
Aragoga, line standing on the Forest Department, Forest Assam, Government of Assam. Correspondent number?
Correspondent number 1, 2, 3, and 4.
1, 2, 3, and 4 has prayed for and is granted further 2 weeks time to file
No, my
affidavit.
lord, he is filing it today itself.
We are filing it today. We'll serve them a copy today.
So I
Lordship.
pray, my lord, your lordship.
Submits that he would be filing the affidavit in opposition on
On
behalf of the state of Assam
On-
during the course of the day. And we will let this matter be listed after a week.
My lord, on 19, my lord, may I pray, my lord.
19 may not be possible.
Your lordship, give a date on 19. If it's not possible, then
19,
on 19, because
19 you fix.
19, Friday. We are blessed.
All right.
Yeah.
Lordship, on the last occasion, court has asked for the final status report of the case, Lordship. This is
Ah.
investigation, Lordship, which is going on. There is a detailed investigation.
What is the matter, sir?
Petition
to refer the investigation to CBI Lordship.
Hmm?
To refer the investigation to CBI Lordship. The petitioner's daughter is missing from 24th of October 2022 Lordship. But investigation could not trace out the missing daughter Lordship. That's why praying for referring the matter to CBI Lordship.
Really, Lordship, on referring the matter to CBI, we are investigating the matter, Lordship. This is under process, Lordship. This is the detailed status report as on today, Lordship.
When she went missing?
24th of October 2022 Lordship.
Then
Lordship, we could not, we are doing our investigation, detailed report is there, Lordship. Now, Lordship,
no, you are doing it, but then you are not able to make any breakthrough
Yes, Lordship.
since 2000, 3 years.
we are doing our, Lordship. That's why we are doing our investigation. That's why we could not file the charge sheet also, Lordship. We are doing, Lordship. Kindly see the detailed report.
You could not trace it even after 3 years.
Why he is objecting, Lordship? I am praying for an investigation by an higher authority, Lordship. He should not
Lordship,
object in
they
that.
will do the same thing, Lordship. What we are, let them tell what
At
we have
least-
not done.
At least petitioner will be satisfied, Lordship, that
Lordship.
the higher authority. also
26,
should-
Lordship, we are in 26, Lordship. Merely referring the matter to other agencies. If there is some lacuna in our investigation,
Who is
then
the
only-
petitioner? Father?
Further, Lordship.
How old was she?
He was around 30 years old.
You will you bring on record. We'll examine and enforce the orders.
So they have brought that record on record.
No, it is the latest status. Let him bring on record.
Yes,
And you reply to that so that we can pass approval.
Yes, Lordship.
Heard Mr. So-and-so, learned consequently. As directed by this court on 0509/2025, Mr. S.S. Learned Government Council placed the status report. Mr. Roy, Learned Government Advocate, Learned Council to place on record by an affidavit by furnishing copy to the Learned Council of the petitioner. Just after
Also,
2 weeks.
Kind of fix a date, Lordship.
2 weeks. After 2 weeks. Just bring on record so that he can go through how, I mean,
If any
what kind of efforts, he may be satisfied also.
Lordship, there is as well from this honorable court, after constitution of SIT also, the matter, since SIT could not find out the missing.
That's why we're
That's
giving
it.
you, because we have taken cognizant that even after 3 years, they are not able to make any breakthrough or,
take back the records.
huh?
Take back the status.
Yes, they work.
On 25th.
Yes, 25th.
I appear for party respondents 10 and 11. I have been included recently. I'll require lots of a week.
Heard Mr. So-and-so Learned Council for the Mr. So-and-so Learned Council appearing on behalf of newly implemented respondent number
10 and 11.
10 and 11, 6 for some time to file affidavit accordingly. Please this matter after 3 weeks. In the meantime, the respondents may file their affidavit.
My lord, here Bricklin, my lord, has been state, my lord.
Huh?
Bricklin, my lord, here the matter participant Bricklin, my lord. My lord, huge
It's
investigation.
a hazardous to the people.
Yes, my lord. Kindly make it some shorter date, my lord.
It's against the environment.
No, my lord.
It's
yes,
polluting.
Not, my lord. What happened, my lord? Not yet started.
It's a
my lord.
polluting industry.
No, my lord, not yet.
Will not allow you to establish.
My lord, not yet started, my lord.
It's okay.
I kindly fix the date, my lord. Kindly, my lord.
Just a business at the cost of the people.
There's a fact-finding inquiry.
You will be earning money at the cost of the people.
No, my lord. There is not single violation. I will put this, my lord. Nothing violation, my lord. Nothing was there, my lord.
The pollution control has withdrawn your NOC.
That is why, my lord. On the what basis pollution control board has withdrawn, my lord.
You are for pollution
No,
control.
my lord. The
Who is for
pollution control
pollution?
there.
Have you filed the affidavit? Have you filed the affidavit?
In this, we haven't filed, but it was a continuation of on a previous.
Anyway, you file it.
I will
I have
file.
said the respondent may file their affidavit. You
Yes.
file it.
Yes.
You justify your, the action.
And
All
the
right.
state government also needs to answer in that matter.
Huh?
State government also needs to answer in that matter.
No, you have withdrawn that.
No, that is
That's why we have said respondents.
respondents, because deputy commissioner has.
All you file. All of you file the affidavit. Right?
May please your lordship, this matter may kindly pass for the time being because my senior lacks in court number 10.
(2014) matter. What is the matter?
Lordship had sought some records with regard to the settlement labor court. Lordship will remember that day it was argued.
Yes.
It was as per the order of this honorable court, which was passed in 2014. The matter was settled. Full and final. So Lordship wanted to see the records and also call for the record of that writ petition which is disposed of. That also contains the records which we have brought, Lordship. That says everything was settled. All the participant workmen were settled.
Just show that.
Lordship, I'll give my record. 251 to 2007 or 0.
I think we have already heard.
Yes, Lordship. Only the record Lordship wanted to peruse. These are the name of the persons, Lordship, who are 51 to 251 207 207. Also the repetitions.
You have,
I've got original records.
no, these are records which you have
Lordship, and the, yes,
brought on record in the writ
no,
petition.
Lordship, I've got the record from the office as per the order of this honorable court.
Yes,
I've flagged the numbers of the person who has signed the resolution.
all of them
Not all of them, we have found 28 numbers. However, the writ petition which was
is also.
yes, sir. These are the names of the person who signed the resolution.
The present writ petition is also
Yes, Lordship.
member of that resolution.
Yes, Lordship. There are 28 persons who are in the present writ petition.
Where is his name?
Lordship will kindly come to page 16, Lordship. The writ petition. That is the resolution on the basis of which this writ petition was filed.
Here or
No,
this
This writ petition, the one we are holding in right.
disposed of writ petition.
That then Lordship will come to additional affidavit of the dispose of writ petition. Second copy to yours. There's the additional affidavit which was filed.
Additional affidavit.
8/1/2013. That was filed.
Yes.
That contains the name of the person who has settled.
Where is this name?
These all 33 persons which were
Where is the name of the petitioner here?
petitioner would be Lordship Basant 30.
Basanta Kumar.
Yes,
Basanta Kumar
30.
Panika. Yes.
And the rest are the person who has signed the resolution to allow him to file the reference in the labor code in 2007 for claiming. So these are the person who has signed the resolution. So they have already settled. Nothing, and the labor code also,
Statement closer employees.
and the award of the labor code also based on the fact these were settled as per the order of this honorable court.
Where is the resolution?
Lordship will come to page 11 of the writ petition, which is presently item number 7, Lordship. That is 496 of 2014.
Present.
Present writ petition, not the disposed order.
Page?
11 is the reference.
Page 11.
11 is the reference and the resolution is at page 16, Lordship. They have annexed. Joint declaration and authorization to the
Page?
16. It is joint declaration and authorization. We, the undersigned permanent employee of employer Messrs. Fadikem Limited, AIDC Complex, to members of the Registered Trade Union, Shramik Kalyan Manch, Fadikem Bonafide.
No, it's okay. This is this is the resolution to for reference.
Yes, Lordship. Paragraph number 2. That in pursuance of the resolution adopted in general meeting of Shramik Kalyan Manch held on so at Bonda, do authorize Sri Basanto Kumar Kalita, President Shramik Kalyan Manch.
He is the petitioner.
He is the petitioner.
So,
on the basis of this authorization, he has filed the Lordship at page 11. That is the reference which was filed.
no, what is the resolution of the settlement of the
Settlement,
management?
Lordship, the settlement were individually done. It was not a resolution. So they everyone, each one of them, they have signed and signed or received amount, Lordship. That is the part of record. Individual copies.
Is it indicates that it's a full and final?
Yes, Lordship. There is, Lordship.
Huh?
Yes, Lordship.
Receipt come undertaking. Receipt from so and so.
That is also part of the writ petition which was disposed of. Is also part of the writ petition which was disposed of.
Where is the particular name of the petitioner in your
Lordship,
this record?
Lordship, I'll just one, Lordship. That is first page, very first page. Basanta Kalita.
Where it is?
The very
Okay.
first piece of the records that I've shared.
Okay, Basanta Kumar Kalita.
I've also numbered by the flag, I've numbered the names as per the table given in the resolution.
Yes, this is on which, what is the date? There is no date.
Lordship, that next page would be the date, Lordship. One of the dates, 2/7/2007. That will petition number 2 that has a date.
Yes. Have you furnished? This is a record you have received.
That is, that is a part of the record of the earlier petition also.
I have severed my connection with the so-and-so. Voluntary with effect. I have no further claim from the said MS so-and-so on any account whatsoever. I shall indemnify keep this for all costs. Yes. Full and final settlement 6,64,727. 12 rupees.
So I may also hand over the second copy of the disposed of reports.
Okay.
So disposed of.
Yes. Full and final.
No, full and final settlement. So, but actually what happened in this case, Lord, the order that was passed by the, what is that? What case?
My point out the impugn order is on the basis of an order of this honorable court, Lordship. Remember?
Yes.
And this order of this honorable court was based on the additional affidavit, which is part of the record of the disposed of, which contains all the receipt, Lordship, of all the 33 employees.
Okay, sir. Anything else?
No,
I think we have heard you on that day. Only this has to be clarified.
yes, Lord.
So we'll pass.
Only one
We'll
thing
pass
that I
the.
would like to, I have
We'll pass the order.
only one thing, that, no?
Yes.
Page 55, Lord, of our read petition. Whatever amount, whatsoever terms and condition is released to be received to the employees by the government through the vertical management employees will accept the payment, but on protest.
What is this?
That is
Resolution.
resolution.
The matter of undertaking so obtained earlier under there is from the employees heraldry raised as another point of discussion.
Undertaking from the individual employees before and of making payment employee dues which are fixed and calculated behind the employee's back. The math.
This is your resolution. Your resolution.
My resolution.
Obviously, you will have this kind of resolution.
That was their calculation and we have accepted this same. That is not the due amount probably they want to say. So we wrote a letter to them. Like,
You are not relying any judgment.
so for judgment, I got some judgment. Like,
What judgment? Once it is finally settled.
that is, no, so far High Court order is concerned, there are two paragraphs, paragraph 5 and paragraph 6. So far paragraph 5 is.
On that basis, only the impugn order has
Paragraph
been passed.
5 is
Your
concerned,
miscellaneous application has been disposed of.
No, paragraph 5 is some observation, and paragraph 6 is the decision. So that the ratio will be paragraph 6, not the paragraph 5. Observations.
By
objection by the Honorable High Court Judge.
while disposing of the earlier writ petition.
Yes.
Okay, yes. Heard Mr. A. Das Gupta. Learned senior counsel. Assisted by what? Petitioner.
D Deka for respondent number 1.
Respondent number 1.
And for respondent number 3.
Hmm. Hmm.
Similar for respondent number 2.
Hmm. Who is respondent number 2?
PF, there no
Okay.
claim is made against only.
You said that is senior counsel, huh? PK Roy Chaudhary.
PK Roy.
PK Roy. Then senior counsel assisted by so and so.
E. Das.
Hearing concluded. Order to follow. Judgment and order to follow.
Retain the records or Lordship?
After the
order.
because we have not started yet.
Lord.
Lordship, please for a reply. After the reflect the
Yes.
Your Lordship, Mr. P. Naik appears for his matter is on legs in another court, Your Lordship. Most of the matter pending, Your Lordship.
Timing.
Hello.
In 13 and 14.
Please, Your Lordship, my senior is on legs, Your Lordship.
What is the matter? Approved early.
May I please, Your Lordship?
Yes.
Yes.
For my learned counsel start, Lordship, Mr. Kyal is out of here.
Lordship, they could have informed me in the morning.
I informed them yesterday. I've called her for taking consent to do the mention in the morning, but they haven't allowed.
Who?
That whom do you
I
call?
called Harshita. I called her. Lordship, I have already called her yesterday.
They,
To whom?
they had
A
informed
junior.
that we should do
A
our
junior,
part.
Lordship.
Lordship, anyhow, we will do our part, Lordship, let them because
No,
it's
it's very,
better.
madam, it's very difficult.
Lordship, we will do our part because Lordship, nothing.
Part
is
her
there.
it's creating a chaos, havoc on me. Part her.
Only Lordship, this matter can be, we are doing this matter only for remand back, Lordship. Remanding back the matter to the authority to decide afresh. That's the only thing. And it is covered, Lordship.
It's a
Thursday.
covered case.
Covered case, Lordship.
May take it on some other day.
Thursday, Lordship.
After a week.
Lordship.
Okay, Thursday, Lordship, will take.
After
Thursday.
a week. Thursday it will be taken.
Thursday after a week. Next week, Thursday.
Next week, Tuesday, Lordship.
Thursday. Next week, Thursday.
18.
As prayed for by
11.
learned counsel.
For the
No,
response.
Mr. So-and-so learned counsel appearing on behalf of Mr. SCK
Lordship.
learned counsel for the respondents.
Agent.
Submits that Mr. K learned counsel has some personal difficulty today. Therefore, fresh for listing of the matter after the week. After a week.
Lordship.
Huh? It is
Next Tuesday also it can repeat.
as agreed to by MS in Haveli learning council for the petition. Let this matter be listed.
On 16th, Lordship.
16, 18,
18. Lordship.
18, 9. This is for claiming that, what do you call?
SVLDRS, Lordship, it's a claim under the SVLDRS scheme.
Scheme.
Lordship, scheme. Lordship, I had filed.
No, it has been rejected. Your claim has been
Claim
rejected.
has been rejected. So
Saying what?
similar cases, Lordship, many cases have been allowed
Saying what?
for reconsideration. My case has been rejected not on the amount, Lordship, not that I'm not eligible. I am eligible. But Lordship, they are saying that once I have been held eligible, they are saying that amount of three amounts I have already paid. They are saying that whether you have paid or not paid, that is in dispute. They may decide, and Lordship, if I have not paid, then they may take the entire amount also. I have no objection. But Lordship, the thing has to come to an end sometimes. Because the scheme we have applied, we have been found eligible. The eligibility is still.
This scheme is still exist.
No, Lordship. It ended on 3/6/2020.
So
36. Lordship, but
what relief
but
can
Lordship,
you?
that is a directory measure. The time limit which is there, the Supreme Court as well as the High Court of Lordship Lordship Himachal Pradesh as well as the High Court of Bombay have held that this is not mandatory condition, it's a directory condition.
No. Problem is that the scheme is over. So what?
Scheme is over, Lordship, but they can take money because now they don't have to decide my eligibility. Only amount is there. So they can still do it. Supreme Court in Lordship Sekhar in resorts have said that they can do it manually.
No.
Yes, Your Lordship.
Even after the.
Yes, your scheme is over. This judgment has come after the scheme was over. This is the objection which was raised in that case also. So the Supreme Court has said that no, you can take it because you can do it manually. If you say that online thing is over, you can take it manually and you can do it. And Lordship Bombay High Court, Delhi High Court and various high courts in all over India, even our own High Court in various cases have held that now also you can do it and you consider
Same
it.
scheme.
Scheme, Lordship.
Same scheme.
Same scheme. I have given a paper book, Lordship, to your Lordship. I think so. If there is
What about our High Court? Same scheme.
Yes, same scheme, Lordship.
Under same scheme.
Another scheme.
Even
yes,
after the scheme is over.
Yes, your Lordship. And Lordship, my
Remanding back for
my-
reconsideration.
Yes, your Lordship. My case was filed before them. Their case is decided. My case has been kept pending for such a long time.
Because of us.
No, Lordship.
Because of us.
No, Lordship. It is because of we councils, Lordship. It's because of us, not before your Lordship.
Okay.
Yes, your Lordship.
Thank you.
Much obliged.
Lordship, this will both the matters, no? 13 and 14.
Both.
13 and 14. Much obliged, your Lordship.
Lordship, Mr. Pinaik is still on legs. There's a pathway hearing going on, Lordship. We fix another date, your Lordship.
What another day?
Is the hearing, your Lordship.
You have completed.
Lordship,
You have completed your submission, right?
we completed, my lord,
You
today,
have relied what judgment?
so we submitted the judgment. If they brought some new things, then we have to reply, Lordship.
There's no new thing.
Only
They
our,
brought as per direction of this, they have
my lord, only come to my Lordship, our affidavit in reply at case number 34, kindly consider, my lord. That's right.
34.
Lordship, annex one. Lordship, it got 34. Page number 34. Page number 34. Our reply.
Yes.
Annex 1.
Promotion to the post of?
Post of Joint Secretary from the Deputy Secretary. I am the Deputy Secretary. All total 3 numbers of vacancies in the cadre of Joint Secretary are to be filled up by way of promotion from
This
Deputy
for
Secretary.
3 months. Only for 3 months.
Question is not
All total 3 numbers of vacancy in the cadre of joint secretary are to be filled up by way of promotion from the as per notification. There is no eligibility. The matter regarding applicable reservation in joint secretary was so it is not. The selection committee went through the records of ACS. 13 members of eligible deputies already comprehended by the. Yes. Then.
Accordingly, my name is recommended.
Jury
Bhattacharya and Jury Bhattacharya.
Yes.
But I am not
See,
promoted.
Sanjuka is entitled to get the promotion benefits for is now senior most deputy secretary after getting retrospective promotion benefits to deputy secretary. Yes.
So there is the issue, my lord. My lord, Lordship, the question is not my lord 3 months. My lord, question is my lord, this is my right.
What right?
Only my lord, if lordship allowed, only my now benefit will only my pension will be recalculated. That is master.
There is the problem, whole problem. Otherwise, what can I do? You have already retired in 2014.
They will recalculate my lord my pension.
Enjoy your evening.
There is our now I cannot be going to the service.
Enjoy your evening of the life. Why?
Lordship, only
Why after
my-
this?
my
You have
pension-
retired as a deputy secretary.
Yes, lordship.
What dispose?
Lordship, that my lord.
Will they say that they have not been heard?
Lordship, Mr. Pina shall appear, your lordship. He is on legs, your lordship.
They've also brought on the record.
What?
They brought on the record on their Eastern College. On the
Yes, they have already.
that pension, our pension will be recalculated.
Huh?
My pension will be recalculated.
Provided you are entitled for a promotion.
Yes, lordship. That is there, my lords. Key number of joint secretary post is there, lords. My colleague gets promoted, I left out.
Not three, there was one.
Understood.
One post was vacant,
There is
but
a
then
candidate.
they could not do the selection process. DPC could not be held. What can we do?
DPC, my lord, therefore, my lord, I cannot tell him. If lordship want to hear them, my lord, then fix another day, lordship may provide.
Lordship may have it day after tomorrow, your lordship.
Why day after tomorrow? All the matters cannot be fixed like this.
Lordship.
Okay, day after tomorrow.
Therefore,
On the prayer of so-and-so, learned counsel so-and-so. This and Mr. And then the matter is listed. Better let the matter be listed on 11/09/2025
for their reply.
as a last. No, please, it is made clear that the adjournment is granted as a last chance. No, it is made clear that no further adjournment shall be granted. Enough is enough. All of the day you are saying that is on the.
Or lordship may fix it in a time frame, lordship. At 2 p.m. there will be.
No, will not give a particular.
Deep levels.